Channel unmute ಮಾಡ್ಕೊಳ್ಳಿ sir. ನೀವಾ ಏನ್ ಸೈಲೆಂಟ್ ಕೂಗ್ತಾ ಇದ್ದೀರಾ?
Might go into the court, my lord. One matter, only the FD has been matured, my lord. The widow wants to withdraw the amount in an accident case.
Tomorrow is.
Please, no, only for.
Full matter, my lord. DD is ready. The bank is not taking the DD, my lord. They are required to pay 1 lakh, 1 crore 81 lakh.
If they have to tomorrow, yes.
Kindly have it on 9th, my lords, 9th.
You can't tell the date. What is the matter about that? I have to know.
Despite there being an interim order to maintain status quo, my lords, respondents are continuously allowing burials of human dead bodies.
Which year is the writ petition?
Petitions of 2013, my lords, pending matter, 2013.
Wednesday.
9th, my lords.
Office objection not complained, my lord. Office objection. That you not departed the amount, my lord.
Madam, 9th,
Who?
9th.
Petitioner.
Single counseling.
DRT matter.
Yeah.
Thursday. Yes.
My lords, the Honorable Trial Court, while deciding a custody application, has not passed a reasoning order, my lords, without any findings on merits as well as the, my lords, this
Wait, custody matter, this court has no roster.
my apologies.
With your lordship's kind permission, my lords.
Yes, yes, Mr. Gautam.
My lords, they had in fact, the father had moved the child welfare committee despite there being a proceedings pending before the family court. This comes under the general miscellaneous. There is an interim order, my lords, but what's happening is in the trial court during the trial, they're trying to take a stance that the matter is pending before the child welfare committee. Therefore, the family court cannot proceed in respect of the custody proceedings. That being the reason I'm moving, there's a pending matter, my lords.
Which year is that?
21, my lords, 21. Day after
Friday.
tomorrow. Friday, it's Friday, great.
Yes.
With your lordship's kind permission, my lords, a matter under the FEMA Act against Reserve of India. Proceedings are 2023 matter. It was heard, my lords, before the coordinate bench, but it was released from Parliament. The lordship can kindly take it on the 9th. I'll take my chance, my lords.
My lord, I appear for opponent in this case. my lord.
This week, the entire board is full.
My lords,
This is
18th,
matter
18th, my
on
lords.
21st. Yes.
Please. Great.
The two matters are settled, my lords. One for posting.
Use the mic.
The two matters, both have been settled. We want for posting.
Matters are settled.
The matters are settled.
Tomorrow, yes.
Your lordship, this matter is sent for twice for mediation. Mediation is not happened because respondent never turned up.
What is the
So-
matter? It's a DRT matter.
MFA, my lord. So kindly.
Which year is that?
2017, my lord.
On the MFA day.
Climate appeal for announcement. Case of amputation.
Which year?
2017.
First, we will, in priority, we will take up the company matters. Because for enhancement, there is no urgency. Company matters, where the stays are there, we need to. We'll see. No, on Friday also, only post the company appeals, not enhancement appeals. Let that be separated. Claimants appeal, companies appeal, separate. We will take up companies appeal first.
Any date, my lord?
We'll see. Yes.
Family court matter, my lord, RPFC is disposed in Honorable Court. RP is filed, husband, but not deposit any amount, my lord.
RP is filed.
Yes, my lord. Not deposit any amount. I am respondent.
Is it a part-heard matter, review matter? Which it will see. Call the list.
Page-wise adjournments. List number 1, page number 5, serial number 16, page number 6, 17 to 20, page number 7, 21 to 27.
My lord, sir, serial number 24, my lord, that it has become infractious. It has been settled between.
Take that.
Filing.
24.
Take the memo. Memo is filed stating that the loan account itself is closed on 24/2/2026, and hence nothing survives for consideration in this writ petition. Accordingly, writ petition is dismissed as withdrawn. Yes, next.
27, 2 days time.
Which one?
27, so sore throat. 2 days time.
Have you informed the other side?
Yeah, other side.
So and so, having present roster. Present roster is with us, RES. Oh. Then why it is listed before us? As WP 5924/2025 is having before the roster bench, list all these matters after obtaining the necessary orders on will TPSs. Yes.
Page number 6, page number 8, cell number 28 to 28, 29, page number 9, 30 to 33, page number 10, 34
Serial
to
number
30.
30 minute,
Serial number
30 minute.
30.
Short.
30. What do you want?
Short accommodation.
Notice
Short
also not ordered. Notice also not ordered.
No,
30.
30, he is saying 30.
30, sir.
30, notice set to be ordered.
Deputy Director, Department of Sericulture.
Take notice for.
You appear for them.
Yes, my lord. Notice not.
R2, R3, R4, AGA takes notice. Land counsel for the petition serve the copy of the writ petition on the AGA. List this matter after vacation.
Cell number, page number 10,
Serial number 36, my lord. Serial number 36, my lord. I pray for 1 week's time, my lord. On 26, a week's time may be granted. I'll file my application for amendment. I need to seek, my lord, in this.
Not application for
My lord,
amendment.
what has happened is on 22nd of February, the government filed an inspection report, my lord. I'll be filing an amendment application urging additional grounds also in that regard, my lord.
Not required. 20, you have an interim order in this.
No, my lord, there is no interim order. We have challenged
Interim
the,
order 22, 26 also, you want some amendment to be filed. When they have filed the objections?
not pleadings are completed from our end, my lord. Only on the last hearing date before the coordinate bench, the government filed the inspection report, which was taken place in 2018. So that ground I am not sure.
Matter after vacation.
Can a date be fixed, my lord, please?
page number,
Grateful.
page number 11, cell number 49, 41,
Serial number 45.
40,
40.
not yet called.
Page number 11, 40, 41.
Yes.
45, in this case.
Page number 12, cell number 42 to 45.
42, your lordship, 42.
Hmm.
Respondent has to file wakalat, your lordship. I am pretty
That's
sure.
not your problem.
No, I am pretty sure I have some.
We'll see.
Serial number 49, madam.
1 week.
1 week time may be.
Somebody is asking for 45.
Your lordship, in this case, we have intimated to the respondent and the settlement tax is going on. Still, they are not filed wakalat, your lordship. Kindly 1 week time.
You don't bother about their wakalat. The court will take care of it.
Your lordship,
We will see what is the matter. Yes, next.
Page number 30, cell number 46 to 50.
Serial number 49, madam.
I am appearing on behalf of the respondent bank in 49. They have challenged the
1
possession
week.
notice and the account becomes regularized and they are recalled the possession notice. The second petition challenging the sale notice that doesn't consider for the survey council.
We'll see.
1 week time may be
No,
granted.
no, let's see. Yes.
Page number 14, cell number 51 to 53. Page number 54.
My lord, serial number 54, my lord.
Two.
Serial number 54. My lord, it's actually a date given matter which is on 8th. I do not know why they moved the matter. Senior counsel is not in town, my lord. I have engaged a
So it
senior
doesn't say about a memo.
It says, my lord, CH, Kotal
Where
moved.
is it? Yes.
The actual date of hearing is, my lord,
No, I
8th
have
of
not
April.
given this matter. Where was the memo given to this matter? I said I've rejected this. Is it that maintenance matter?
Please,
Where 2
please,
lakhs,
the same.
5 lakhs?
Please, please,
I've
please.
rejected it. How come it has come?
My
I
difficulty is,
remember the other day when they moved, I rejected it.
date is anyways on 8th of April, my lords.
No, they've moved it, I rejected
Yes.
it. Why is it in the list? So what, I've rejected 2 times. Let it come, we'll see.
Please, my lords, grateful, please.
Yes.
List 2, page wise adjournment, list number 2, serial number 1, orders. Page number 2, serial number 5, 6.
My lords, list to serial number 6, please, my lords. I'm appearing for the petitioner, please, my lords. Kindly requesting that the matter be dismissed as withdrawn, my lords.
Where is the memo?
My lords, I'll file it. Kindly pass over, my lords. Grateful, my lords.
My lord, list number 2, serial number 3. It's for notice to R2, R4, R5 and 6. We paid the PF. Notice may kindly be ordered to R2, R4 to 6.
We will see what is the matter about. Then if required, we will issue notice.
Page number 4, serial number 7 to 14.
My lord, serial number 13, my lords. I'm for the petitioner. I've informed the other side. I'm led by a senior counsel, my lords. He has some difficulties today. I've requested the other side.
Serial number?
13.
You have moved the memo. Who moved the memo?
Yes, they might have moved it, my lords.
You moved?
No,
Who has moved the court?
I have not.
Court officer has moved.
No, my lords.
We are
personally.
yet to file objections, my lords.
Huh?
We are yet to file objections, my lords.
So why is it listed is the question. A memo is moved. And now you moved it, how can the petitioner seek for time?
Old memos. They are all old memos, not before our roster. Memo moved not before our roster.
Then how can they list all the matters? Then why are they listing it as a memo mode? They can post it as well. Ask them, what is this matter about?
Respondent number 2 to 4 are the contesting, my lord. They are the answering respondents.
Pollution control
Board, my lord.
We filed wakalat. I'm yet to file my objections, my lords. I also require time, my lords.
When did you file your wakalat? When did you receive notice?
Long back, my lords.
Then why are you not filing your objections? As per the writ rules, your right to file the objection shall be forfeited.
Any date may be given, week's time.
Does this matter? On 28th of April, by the time if the objections are not filed, the writ petition will be heard on the merits of the matter. And find out from the registry why they are listing the matters like this.
Unless there's an interim order which needs to be extended.
Interim order is extended till then.
Grateful.
No further time will be granted.
Page number 5, serial number 15.
Please call the list.
1. List number 1 for orders matter, serial number 1. Subramaniam Bhattam for
This
petitioner.
matter pertains
Here
to
for the
granting
respondent,
of,
Lord's statement of objection, the copy has been served to the petitioner, Lords. Today we'll file the acknowledgement, Lords. Kindly 1 week time may be given.
Served or not? It is served on you or not?
Lords, it's served, man.
He is accepting it. Why should you file an acknowledgement now?
Obliged, Lord.
Yes.
Lords, the matter pertains to granting of license for petrol bunk outlet, my lords. My lords, it may be taken on Wednesday or Thursday, my lords. The arguing counsel is out of station.
This is a matter on Thursday, no further adjournment. The counsel for the petitioner submits that he has received a copy of the objections.
Serial number 2.
Obliged.
NBS, serial number 2.
I represent for petitioner in the above matter, my lord. I seek 1 week time to comply with the office objection, my lord.
Give the papers. Declaring that the petitioner decree holder is entitled to the attachment of monies from the proceeds of auction sale by respondent number 2. Who is respondent number 2?
Society, my lord.
The National Cooperative Bank.
Yes, madam.
As per Annexure A, towards the decree amount in accordance with Annexure B.
Yes, my lord.
What is the declaration from this court?
My lord, the entire case is all about my lord. I'm the decree holder before the trial court. Judgment debtor is the respondent number 1 before this petition. 2 to 4, because I am the decree holder, where the property, the proceedings of the property has been attached in my favor. Prior to that, my lord, I recently came to know that it has been.
What is the order in question?
My lord, order in question is whatever the auction has taken place by the bank.
Where is that? There should be for filing a writ of mandamus.
Yes, my lord.
And what is this declaration? Can there be a declaration by way of a writ? Can there be a declaration?
I mean, it is in the nature of direction. I am sorry, my lord.
How can there be a direction? You have not assailed anything. You just say, issue a declaration that I am entitled to recover the money.
Sorry.
Now, if you are a decree holder, there must be an EP.
Yes, my lord. EP has been.
Execution proceedings, what happened?
It is still pending, my lord.
Then why will the High Court declare it you are entitled?
No, my lord. I sought for an attachment before the trial court of the judgment debtor property. Subsequently, I came to know, my lord, his property has been mortgaged to the bank, that is respondent number 2 herein. So I sought for an attachment towards the property, whatever the auction proceedings that have been taken place. Remaining amount should not goes to the judgment debtor. It has to be come to my way of attachment.
So filed an IA.
Yes, my lord.
What happened to that IA?
That came to be dismissed, which is there at Annexure B, my lord.
Where is that order? Have you
Annexure,
questioned
yes,
that
my
order?
lord. Yes, my lord. It starts
Come
with.
to your prayer. Come to your prayer. Where did you question it?
My lord, I just stated only whatever the proceedings that has been realized by the bank, the balance amount has to be entitled to the petitioner herein.
Look at your prayer. Can you seek such a prayer? Please read your prayer.
Declaring that the petitioner decree holder is entitled to the attachment of the money from the proceeds of any auction sale by respondent number 2 and 3 as per Annexure A towards the decree amount in accordance with Annexure B. I have written, my lord. Just to join that order. Well,
Directing the jurisdictional sub-registrar to register encumbrance.
in favor of petitioner till disposal.
Can you seek all these reliefs before this court?
No, my lord, I sought before the trial court that came to be rejected. So
What will happen? You have to question that order. Where is that order? What is the relief you should seek to set aside the order dated so and so, passed by so and so?
My lord, it has been partly affirmative. They have stated.
Then whatever partly not, whatever is against you, that has to be set aside.
Yes, my lord. Only to that portion I have mentioned the prayer, my lord, because what I have stated, my lord, what they have stated, surface proceedings I won't touch before civil court. As per section 34, it is barred before CPC. They have stated. And whatever you wanted to realize the amount from the judgment debtor, you have a separate provision.
What is the GMRES? This is a GMCPC
Yes,
matter in that case.
But since I have challenged the auction notice, my lord, before this court, so they have classified under.
It can't be this kind of reliefs. Either you have to question the order of the trial court in dismissing your application, isn't it? And if you are questioning the auction notice, that is a separate proceedings.
So I seek time, my lord. Next week, next week it may be fixed up, my lord. Please.
From 2022, this is how it is. What relief your client would get in this writ petition?
No, my lord, at least I can recover the money from.
You can't. You have to go. You have to seek appropriate relief before the appropriate court.
Next week.
List after 1 week. And now that day I'm going to dismiss this. Whatever you want to get instructions, please get.
Please.
This is matter next week. No further adjournments. 3.
Bill number 3, HR Vishwanath. Bill number 3, HR Vishwanath.
The writ petition is of the year 2022. So far, the notice is not even served. There is no representation on behalf of the petitioner. The present writ petition is filed, questioning the notice dated 10/3/2022. Where the proceedings were initiated and the Surface Act, the writ petition before this court is not maintained accordingly. Writ petition is disposed of, giving liberty to the petitioner to avail the alternative remedy. Don't say about 14 and all. Yes. Next, fourth. Two matters are listed today like that. If that, then there is no memo, why should you write it as a court moved? Don't be careful. Yes, next.
Cell number 4. Cell number 4.
I represent for petition. in
And
this.
yes.
I am for the respondent bank minutes.
Give that.
My lord, I praise time to.
Any interim order in this?
No, ma'am. No petition, my lord, petitioner is already say.
Use the mic, switch on that mic.
This mic is on. Mic is on.
My lord, petitioner is a subsequent purchasers, my lords. There are 5 writ petition filed by the, 4 of them are a subsequent purchaser and 1 is a borrower. And out of that, 8
All of them are pending or disposed?
1 is disposed.
Remaining
8
or pending?
Remaining.
Give the list all those matters tomorrow.
Yes.
What is this? Cell number 5.
My lord,
Yes.
it may be posted
Cell
for
number
next
5.
week, my lord. This
Lord,
this petition.
why? Which matter?
Fourth one, my lord.
Why?
We will be ready for arguments with all other petitions also, my lord.
First of all, this writ petition against this bank is not maintainable before this court.
No, my
Look at
lord.
the maintainability issue.
For serial number 4, my lord, it is maintainable because I'm not the borrower, I'm not the guarantor.
I'm talking about the respondent. Again, it's not respondent, it is not maintainable.
No, my lord, I will make submission. It may be
Day
posted by
after
next.
tomorrow.
Please, ma.
Yes, next. 5.
Number 5. Parashuram A.N.
My lord, in this matter, for respondent number 4,
My lord, in this matter, my lord, the learned counsel is appearing before the DRT. The bank has assigned the matter to them. My name may be deleted and that Sri Deves.
Delete the name of Mr. Francis Xavier for R4.
Yes, ma'am.
In the name of
J.M. Patil, my lord.
J.M. Patil. Yes.
Copies
Yes,
are
Mr. Counsel.
The copies have been served.
What is the
My
writ
lord,
petition about? Come to the writ petition.
The petitioner is a innocent home buyer who has bought, who had booked a home from respondent number 4, who is a builder under.
Bipartite agreements?
My lord, I have not, I don't have the
No,
petition.
the only thing
copy,
is
my
if
lord.
it is that, we will have along with the
No,
bank.
generally ICICI Bank will not have the tripartite agreement, my lord,
Let's
only,
see, let's. ICICI Bank, Skylark Mansion,
they don't have the
Chase,
tripartite
Chase Union.
agreement.
Yes.
Allah, who do? Copy.
So papers honor. Papers are served on you?
And papers are not served on me
So
yet.
papers honor.
Please, Your Worship.
Like counsel, the petition is right to serve the copy of the writ petition on the council. List this matter on 21st.
Obliged.
Cell number 6. Asha D. Joshi. Memo.
Filing the memo, my lord, to one submission, interim order, may kindly get.
Interim order, look at it, wherever interim order is there, extend. Yes,
Filing a memo, my lord, to withdraw the writ petition.
take that. Memo is filed seeking to withdraw the writ petition. Your memo has to be, order has to pass on that.
Yeah.
A memo is filed by the counsel for the respondent Is withdrawing the writ petition, why do you?
Withdrawing, my lord, please, please. We have been, we have got the instructions that they are withdrawing it. So it has
That's
been
what,
settled.
any orders to be passed on your memo for retirement?
It is after that we have received the instructions, my lord.
Hmm.
So please,
Shall I pass?
please.
A memo is filed seeking, a memo is filed by the counsel of the respondent to retire from the case. Accordingly, the petitioner, the respondent is permitted to retire from the case. Then after that, a memo is filed by the petitioner seeking to withdraw the petition. Accordingly, dismissed as withdrawn. 7.
Filed notes along with an affidavit for withdrawal with liberty to file a fresh writ petition in the event notes respondents refuses notes. There is an.
What is questioned in this?
Not possession notice is challenged. Not in the meanwhile, not they have offered one-time settlement. Not I have deposited 5 lakhs notes in terms of their requirement.
Have you complied with the interim order dated 30?
Yes, my lord, that is already complied. And interim order is operating, and there was a negotiation in which my lords, they have informed that I have to pay 5 lakh additional, and I have deposited.
Well, stating that there is a settlement between the parties, and the petitioner wants to withdraw the petition. It is submitted that in case there is any further, any subsequent action, you may be permitted to, liberty may be granted according to the petition dismissed as withdrawn, giving liberty to the petitioner.
Obliged.
In case any, to avail the appropriate remedy, in case any further proceedings are initiated by the bank. Yes.
Nanda Kumar, Divya Purandar.
Lords, I am for the respondent. Your Lord.
No representation for the
Lords,
petitioner.
loan account has been cleared, my lords.
Clear.
They have cleared the
Land
loan
counsel
account.
appearing to the respondent. No, there is no representation on behalf of the petitioner. Land counsel for the respondent submits that the loan account is
Has been cleared.
closed.
Closed, my lords. Yes,
No,
closed.
no account is closed, hence nothing survives for consideration. Accordingly, dismissed as infructuous. 9.
Till number 9. Till number 9.
For the respondent bank,
Moinuddin.
the third party, my lord, it is not maintainable. Up also not.
No representation for counsel for the respondent is present. Is this matter for dismissal tomorrow? Yes, 10.
10. Till number 10. Sandhya U. Prabhu, for petitioner.
Here for the petitioner, my lord, I am just appearing as a proxy for my senior counsel. Appearing as a proxy for my senior counsel, she is out of town, my lord. My senior counsel is out of town.
Every time she's seeking adjournments, on the last occasion, I made it clear that no further adjournments will be granted. It is reflecting in the list. And what is, and why is she asking for time? List this matter tomorrow, in spite of the matter being listed, and where it is stated that the no further adjournments will be granted. Again, the adjournment is sought. Finally, for accommodating the petitioner, list this matter tomorrow. If the same request is made tomorrow, the writ petition will be dismissed without even going into the merits of the matter. Yes.
7. Suresh, HM.
I appear for the respondent bank, my lord.
Appear for
This
the
writ petition has become infructuous, my lord.
Yes.
He has sought for appointment of ADLR, Additional Director of Land Records, for demarcating the mortgaged properties and the properties belonging to the petitioner. Then this honorable court directed the recovery officer of the DRT Bangalore to take assistance of the ADLR and to take possession of the mortgaged properties. Accordingly, the recovery officer of the DRT has passed orders and directed the ADLR to assist the bank to take physical possession of the property. Now, this writ petition does not survive.
What is sought is allow the writ petition
Lordship.
issuing a mandate to
My
consider the pending application.
No, that prayer is wrong, my lord. Prayer is, they had filed an application before the recovery officer to direct the, for a request.
IA number?
IA number
74 of 23.
74 of 23, my lord.
That's what is the relief I'm looking
Yes,
at.
that has been considered and.
Considered.
Considered, yes.
Yes, the represented petition is filed, seeking the following prayer. Both
My
the
lordship-
counsel submits.
My lordships for petitioner. The report of the ADLR is still pending, my lordships.
That is not what you wanted. You wanted the court to pass
Yes.
such order. It is already passed, and that will be considered.
No,
The-
my lordship, the portion of the property stands in my property as well. That the entire property doesn't belong to the institution which has mortgaged the property. The item number 4, 15 to 80 square feet.
No, there is another, 1 minute, there is another prayer at B
Yes, my lordships.
to quash the order dated 9/9/2024.
Yes, my lordships. Why? Because it's the portion of the building stands in my property. Since the
So
institution
why do you,
didn't have an access.
1 minute, why do you say that it has become infructuous?
My
He's
lord,
questioning some order dated 9/9/2024.
my
Why-
IA number
This,
73 is pending.
No,
It is
he has not, even though there was order, he has not paid the process fee, my lord. No notice has been served on me. I have filed the caveat petition. Even then, office objections were not complied. He did not serve the copy on me also.
Don't go into the
Yes.
merits of the matter.
The copy has, I will serve the
There's a
copy.
whole difficulty in hearing a counsel. This is matter after 2 weeks.
Item number 12. 12, Ayasa BG for petitioner. Shankara.
I am appearing with the respondent bank, my lord. Petitioner is challenging this 13(2) of the surface area, my lord. It's a demand notice.
No
He cannot be
representation.
challenged.
But the petitioner, counsel, the respondent, please present. There is this matter for dismissal tomorrow. Yes, 13.
Cell number 13.
Appear for petitioner. Senior counsel is online.
Where is he?
My lord, it has to be allowed. There is some system allowed.
She's trying to log in, my lord. Senior counsel Lakshmi Angar is on video conference. They're not allowing, I mean, she's not being allowed. That's the reason.
She has not connected.
It's not connected.
Participants are lila.
Pass over.
My lord, it may be taken up on Friday, my lord.
She's
She's traveling today, my lord.
Friday.
Public.
Then cell number 14. Cell number 14.
My lord, kindly pass over, my lord, for R3 to R5.
What is the writ petition?
No, only I'm restricting only, my limited scope is, the stamp duty has to be paid.
Assignment
As per-
agreement is
assignment
under
deed.
challenge.
Oh,
That is registered in Maharashtra.
why is this matter adjourned on the last occasion? I heard it.
Yes, lordship, only to the specific point, how this is maintainable, that was the question.
So you were relying on a judgment of Madras. Then the similar provision is not there in the Karnataka Stamp Act.
Yes.
So
And-
then this petition has to go.
Then the writ petition that what stamp duty they have paid in Maharashtra, at least they should be endorsed in the sub-register office in the Karnataka.
That
As per
you
registration.
can't
Lordship,
raise something
exactly.
which is not there in the act. That's not your concern at all.
My submission, suppose DRT, if the matter is, because is pending adjudication DRT.
No, your submission number 1 is now, it can't be considered as it has no legs to stand. Number 2, from where you say that it has to be endorsed. Point out at the Stamp Act and tell the court.
The Registration Act.
Hmm? Registration Act.
28, place for registering the document relating to land. Only, at least to that extent, it should be endorsed, it should be acknowledged.
No, let's see if the act says so, we will ask them to do it. You can't assume something. Which provision?
28, my lord, section 28, place for registering the document relating to land.
Hmm.
Save as in this part, otherwise provide every document mentioned section 17 subsection so and so.
No, you're
Such
reading
documents
20
affects
you're
immovable
reading 28 of the
Registration Act.
1 minute.
Even otherwise also.
1 minute. No. First, let's see. No, otherwise. 28, what it says.
Place for registering the document relating to land.
Hmm.
Hope your lordship got it.
Yes, sir.
Save as in this part, otherwise provide every document mentioned in section 17 subsection 1, clauses A, B, C, D, and E, section 17 subsection 2, in so far as such document affects immovable property, and section 18 clause so and so shall be presented for registration in the office register within whose sub-district the whole or some portion of the property to which such document relates is situated.
Where it talks about endorsement.
That has to be registered, sub-register. But they are registered in this assignment deed, they are registered in Maharashtra. That they want to execute in Karnataka. Suppose if the paid,
Karnataka Act provides for that or not? He has he has drawn the attention of the court to a particular provision.
in
If
the,
there is no point, what I request advocates is if there is no arguable point, let's leave it there. So that we'll be able to give some more time to the matters which has some,
otherwise one submission shall I make, my lord. Anyway, the matter is pending adjudication before DRT with regard to section 14 is concerned. There also I want to take up this argument and this contention before DRT.
already you have wasted two days. I'm not going to give that kind of any liberty. I'm going to decide it.
Yes, my lord.
I'll say that whatever is, the writ petition has to go on for these reasons. Please come.
My lord, one submission. This matter has to be connected. The last hearing itself, one matter, one matter has to be connected along with this writ petition.
That 14.1 is there, 14.1.
It is not there for, it is there 14.1.
Already there.
Both, one more is
Which
there.
matter is it?
Yeah,
They were total.
It is some other matter.
it is there.
That will come later. We'll dispose of these matters.
Yes, sir.
This WP number 13563 of 2025 is filed seeking the following prayer. It's a case of the petitioner that the first respondent company, based on the assignment agreement dated 1/10/2020, has invoked the measures under the Surface Act. Basing on a demand notice dated 10/6/2020, issued by the second respondent bank, it is stated that the first respondent bank ought to have reclassified the account as non-performing asset subsequent to assignment of debt by virtue of the assignment agreement dated 1/10/2020. It is stated that the petitioner has taken the loan in the year, has approached the second respondent bank and taken the loan in the year 2018. He has availed a credit for the loan facility of an amount of rupees 5 crores 30 lakhs. That the same was obtained for the purpose of development of the electrical goods and equipment business. Due to COVID-19 pandemic, as the petitioner could not pay the amount, and the account was classified as NPA as on 3/2/2020. The second respondent bank has issued a demand notice under section 13(2) of the Act. Thereafter, the second respondent bank assigned the debt to the first respondent reconstruction company by executing the assignment agreement dated 1/10/2020. It is a case of the petitioner that the first respondent company ought to reclassify the account as a non-performing asset, and it cannot continue the proceedings from where the second respondent has left. Thereafter, an order was passed under section 14 by the ACMM and ACMM court, criminal miscellaneous number 5026 of 2023, dated 22/10/2023. It is a case that the first and second respondent bank, without paying the requisite stamp duty as prevailing in state of Karnataka, had issued the possession notice. Surprisingly, without appreciating these facts and questions of law, the Declaratory Tribunal dismissed essay number 105 of 2023 on 29/4/2023. It is a case that unless until the said assignment is registered in the state of Karnataka, the same is not enforceable. Hence, he has come before the court to set aside the assignment agreement dated 1/10/2020, registered before the office of the sub-registrar office of other state on the assets and liabilities situated in the state of Karnataka. Land counsel appearing for the petitioner. Where are the judgments?
The division bench.
Has relied on the judgment of the High Court of Madras in case of Veena Textiles Limited and another versus the authorized rep officer IFCI Limited and another arising out of WP number 8761 of 2014. He relied on paragraph number 13, 14 and 15. It is submitted that in the similar circumstances, the High Court of Madras has held that such assignment which is not registered in the area, before the sub-registrar in whose jurisdiction the property is situated is not enforceable in the eye of law. It is submitted that in this case, the assignment is registered at Mumbai. Yes, Mr.
Yes.
Registered at Mumbai and the properties are situated at Bangalore. As such, the assignment is bad and the same has to be set aside. Land counsel appearing for the respondent bank, you're relying on some judgment?
Lordship, not relying.
Has drawn the attention of this court. What are the provisions?
28B.
Has relied on section 28B of the Karnataka registration.
No, 28B of Madras High Court. I mean, Tamil Nadu judgment. Tamil Nadu Stamp Act, Registration Act.
What about this? What about Karnataka?
Karnataka is only 28. There is no AB.
Let's see. He had relied on section, and the schedule also have shown.
Here, Tamil Nadu plus Karnataka, everything is included in the assignment. That is my question. In that assignment deed, they have included Tamil Nadu properties, Karnataka properties.
Then if they have included Tamil Nadu properties, Tamil Nadu person aggrieved by it will question it.
If I challenge before the allow,
no, you can't go before the Tamil Nadu. Your property is here.
In Karnataka.
But if I challenge the order passed by the earlier, example, kind permission, DRT, dismiss. Again, I have to challenge before DRT. DRT is the jurisdiction to decide all these points, including the Tamil Nadu. Tamil Nadu comes with the.
But Tamil Nadu, because the DRT is situated in Tamil Nadu, whatever the laws that are applicable to Karnataka, they will not apply the law of Madras. They will not apply. Yes, the Land Council has relied on section 28 of the registration, Karnataka Registration Act, the Registration Act 1908. It's a Registration Act 1908. Which reads thus. And what else? The other day I've shown some of the
Lordship, Stamp Act 19, section 19. What it says is any additional amount is payable only then stamp duty is attracted.
Section 19. He has also relied on section 19 of the Karnataka Stamp Act.
Karnataka Stamp Act.
He relied on 19A of the Karnataka Stamp Act. So 19A, you please extract. Relying on this, it is submitted that the judgment that is relied on by the petitioner is not applicable to the facts of this case. It is submitted that in the as far as the state of Tamil Nadu is concerned, they have section B, 28B.
Lordship, 28B is very specific to Tamil Nadu, which is not there in.
That is what I am saying.
Yes, Lordship.
I am asking you that.
Yes, Lordship.
It is submitted that section 28B, which is specific to the state of Karnataka, Tamil Nadu, it says any document registered outside the state of Tamil Nadu in contravention of the provisions of clause A shall be deemed to be null and void. It is submitted that such a clause is not there in the, as far as the Karnataka is concerned. The judgment has been rendered in the light of section 28B. It is submitted with the land council that as far as Karnataka is concerned, and this document is registered prior to, which year is this?
2020.
When is the amendment? The other day you were telling about the amendment also.
There is no amendment, Lord.
No, they are enhanced to 5 lakhs, please, sir.
5 lakhs amendment is much later.
What is that? That's
That is
what.
24.
23, 24.
I remember your submissions about a month back, and you are not telling the court what it is. It is submitted that there is an amendment to the Stamp Act, where now it is enhanced to 5 lakhs.
Yes, Lord.
At that point of time, it was 2 lakhs.
No, 1 lakh. 1 lakh.
And
Yes.
the petitioner has paid the requisite stamp duty and requisite charges and registered the document. As such, it cannot be questioned before the court. It cannot be set aside. Further, it is submitted that when the petitioner cannot come before this court, questioning the same, as he has an efficacious remedy before the DRT. Next para, having heard the counsels on either side, there is a material on record. Petitioner is questioning the assignment deed. The admitted fact is that he has availed the loan from the second respondent. Later, the second respondent has assigned the loan to the first respondent asset reconstruction company. One of the contention is that when a 13-2 notice is issued, as account has become NPA, again when the debt is assigned to the first respondent company, the first respondent company has to initiate the proceedings afresh. That submission has no legs to stand, as when the debt is assigned to the first respondent company, the first respondent can proceed from the date from where it was stopped by the second respondent company. Then coming to the contention with regard to the assignment deed is concerned, this court finds force in the argument of the learned counsel for the respondent that section 28B is specific to the state of Tamil Nadu and does not apply to the state of Karnataka. There is no such provision for the state of Karnataka, and both the Stamp Act and the Registration Act does not have any rider as such, and the petitioner and the respondent has registered the property in the state of in Maharashtra, and in the light of both the Stamp Act and the Registration Act, as there is no requirement as argued by the land counsel of the petitioner, this court do not find any reasons to interfere. Accordingly, dismissed. Give the next file.
Same also the Karnataka. Same Karnataka Stamp Act and jurisdiction assignment, same. Almost that is similar. The contention which you have taken, with regard to the assignment.
Same.
Similar.
But the counsel on record is expert. I have filed my wakalat.
You filed your wakalat, yes.
Because he is
Delete this in 14.1, delete the name of Nanjundappa.
He is expired, no more.
Yes, he is no more. It is stated that he is no more. And Mr. M. A. Rajendra has filed his, in this matter, remaining other contentions, everything, only the facts will change. The petitioner what is this writ petition? No facts at all.
This was prepared by my jurist.
No, that's what, straight
Earlier
away.
counselor, he has
straight.
compared almost all this one. But
No.
I have segregated only to the text only. I
No
argued the
facts of the case. Petition is a customer of the first respondent bank.
No, that
Second
petition,
respondent filed IA.
that petition what he has filed, that I don't want to comment on that. But
No,
anyway,
it's not about comment. Now, what will the court, how the court will record the facts?
only to the extent of relief, what the sought illegal assignment only.
The
to
writ petition is filed.
Lordship,
Seeking the
if I can submit, this is in a OA,
This is
whereas
in
my
OA.
situation was in a Surface Act.
The writ petition is
OA.
filed questioning seeking the following prayer. The petitioner is the borrower. The first respondent is the first respondent. The petitioner has availed the loan from the first respondent and the same is assigned to the second respondent. In turn, the second respondent has filed the IA number 1932 of 2022 along with an assignment agreement dated 26/11/2021 to order substitution of the second respondent in favor of the first respondent. And the DRT has allowed the application on 21/12/2022 and substituted the second respondent in the place of the first respondent bank. On 27/12/2022, the petitioner has filed I number 3423 of 2022, dated 27/12/2022, praying to recall the order passed without even hearing the petitioner. The DRT then what has happened to that?
That OA is pending adjudication.
No, IA is also pending.
No, IA is the.
You filed a petition to recall the order.
Yes.
That is on 26/11/2021. Then why did you come before the court agreed by the order dated 21/12/2022?
Because since they have allowed the for substitution, again, that order only has approached.
That you have filed a recall application.
A recall application.
Having filed a recall application, why did you come here?
That got dismissed, I think, Your Lordship.
Where is that?
The page number 63, my learned brother, as Annexure D, IA to recall the orders dated 21/12/22, he has mentioned it.
Where will you get that order?
On 21/12, page number 63, my lord.
Page number?
63, Annexure D, IA number 3423 has mentioned it.
This is what I'm asking. This you have filed. Pending that, why did you come here? What happened to that order?
That's order. But here I am going by his prayer only, my lord, to set aside the illegal order dated 21/12.
That's what that I've seen. The order
Passed by
dated 21/12/2020.
Allowing assignment means most probably it is.
That I understand. They have accepted the whatever their application to
substitute.
That is allowed. Then you filed a recall petition. Then why did you file the writ petition? What happened to the recall petition?
Yes. What your lord?
I think there is no, even in the facts of the case also, there is
no
nothing.
mention about that.
Because it says agreed with illegal order dated 21/12/2022. If had you questioned the recall order, the date would have been something else.
That is not there. That is not there.
The filed a recall petition. And pending the same, the present writ petition is filed. It is stated that the branch, the ARM branch Mumbai and ARCIL Mumbai has no jurisdiction to assign the debts and immovable properties situated in the state of Karnataka. It is stated that any assignment agreement to be legal and valid, it should be executed between first respondent banks, ARM branch Bangalore and ARCIL Mumbai on Karnataka stamp paper by paying proper stamp duty to the government of Karnataka. as the said assignment deed is bad, the petitioner has come before the court. Then counsel appearing, who appears for the respondent?
I am appearing for the
Then
respondent.
counsel appearing for the respondent submits that. Which respondent?
Respondent number 2, my lords.
Karnataka Bank,
Yeah, RC, my lords.
asset reconstruction.
Yeah, please, my lords.
It is submitted that as per the guidelines issued by the Reserve Bank of India, it is permissible to assign the debts to the as a asset reconstruction companies. And as per the circulars issued by the Reserve Bank of India from time to time, the assignment is the debt is assigned to the respondent to the second respondent asset reconstruction company. It is submitted that there is no, as per the Karnataka Stamp Act or the Registration Act, there is no prohibition to register the document in Mumbai. And as per the provisions, and they have by paying the requisite stamp duty and registration, they have completed the registration. It is submitted that petitioner only with an intention to drag on the proceedings has filed the writ petition before this court. Next para. Having heard the counsels on either side, there is the material on record. The first respondent has assigned the debt in favor of the second respondent company. And all the grounds that are raised that the assigning the debt to in respect to the properties that are situated at Karnataka is not maintainable, and all that it should have been a stamp paper obtained from Karnataka. All these grounds have no legs to stand. The debts are assigned to the asset reconstruction companies as per the guidelines issued by the Reserve Bank of India. And further, if a particular document is unenforceable or non-est in law, or it is contrary to the provisions of the Act, the petitioner ought to have pointed out at the particular provision of either the Stamp Act or the Registration Act. In this case, the petitioner has relied on the judgment of the Madras High Court in so and so. From there, the same discussion like in the earlier case. Accordingly, the petition is dismissed. And the order of the DRT and so as there are no reasons to interfere.
Not only RBI guidelines, section 5 of the Surface Act also permissible to.
Section?
5 of the Surface Act. Not only
Section
RBI
5 of the
guidelines,
Surface
it's a mandatory.
Act.
But we
Permits
cannot
them.
question. The assignment is permissible. Section 5 of the Surface.
5 of the Surface Act also.
5(1) and 2, Lordship.
Huh?
5(1) and 2 also.
5(1)(2) of the Surface Act
Permissible.
permits the bank to assign the debt. Yes.
That we cannot question also. Oblige, my lord.
Yes.
15.
Apply.
Cell number 15, Srinivas V. Kailash Kumar for respondent 1.
My lordship, in writ petition 10914, serial number 14, a date may be granted, my lord. This had to be connected to the previous matter. You said, let's dispose this, right? So can you please grant a date for
That
this
also, that matter is tomorrow,
matter? Wednesday, my lord.
Wednesday. Is that matter on Wednesday? Yes, what about this?
My lord, appearing for petitioners, my lord, the service of notice is awaiting with respect to R2 to R6.
Let's see what is the writ petition.
Please, my lord. My lord, in
Whether
this-
required or not, we'll decide.
Please, my lord.
What is question before this court?
My lord,
To quash the
Annexure
order
C.
dated 31/12/2025
Annexure
passed
C,
by the
my lord.
Debt Recovery Tribunal. What is order by the Debt Recovery Tribunal?
My lord, page number. My lord, the Honorable Tribunal has dismissed the
No,
petition on
where
the
is
ground.
the page number? Which page?
And 166, my lords. Page number 166, Annexure C.
Who appears to the Jammu Kashmir Bank? Sailesh Kumar, where is he? Any other proceedings were pending between the parties?
No, my lords.
Then take out notice on the counsel appearing before the trial court, before the DRT. DRT, anything is pending?
No, my lords.
2022, till now you don't even take notice, pay the process.
The process is paid, my lord.
Huh?
Process has been paid, my lord.
When did you pay the process?
Lord, on 17, 3, my lord, 17/3/2026.
Hmm? Yes, list after service of notice. Yes, next.
Cell number 16. Hearing on IS, cell number 16, Harini
In
MS.
this case, I had taken a notice. I have not yet collected the wakalat and also papers. Any short date maybe, next week any date maybe.
This is
The review
matter,
petition then maybe there.
this is matter on 21st.
Please, ma'am.
Cell number 17. Cell number 17, Lata S. Shetty,
The petitioners will
Puram,
for the bank to come up with a proposal as per the previous order. Was for the bank, my lord, to come up with a proposal. Settlement was.
The memo for compliance has
Why
been
the
filed.
mics are not on or I'm not able to hear?
I've just now received the memo, my lord. I'll just now receive the memo. They filed a memo of compliance, coming up with a proposal. I'll just seek instructions from my.
Just now,
We served it on.
the respondent has just has served a memo of proposal to the counsel for the petitioner. Then counsel for the petitioner seeks time. Let's this matter when?
A week, 2 weeks time, my lord.
Why 2 weeks time? List it on 16th.
Please, ma'am. Interim order may be kindly extended.
Interim order all granted is extended till
Grateful.
then.
Great.
cell number 18, cell number 18,
Statement is provided now, my lord. I'll verify, submit on Wednesday, my lord. I may be permitted to file. Earlier days.
Take it, statement of objections filed by the respondent.
Statement of accounts.
Statement of accounts filed by the counsel for the respondent is served a copy on the petitioner. List this matter,
Wednesday, my lord.
Wednesday. Yes, next, 19.
cell number 19, cell number 19,
I'm for the
Nabid Ahmed,
Sale notice has been challenged.
Pass over, my lord. Senior of Pakkad Kota. Pass over, my lord.
Pass over.
cell number 20,
May I take-
That's time for the petitioner in this case.
Taken up by
Milords.
2:30, Your Worship.
Milords.
2:30, Your Worship.
Milords.
Passover is whenever Passover is called. Yes.
20, Vinayak Kamath,
20.
20 only,
Plus 20.
20 you want Passover?
Yes, Your Worship.
19 also.
Yes, Passover.
21, preliminary hearing,
I was thinking in the earlier matter, you were saying 2:30. Yes.
21, Veerbhadra Swamy. for
You
petition.
that. No representation for the petitioner. Let's this matter for dismissal tomorrow. Yes, 22.
22, cell number 22, Jai
Mr. Paper.
Prakasham,
This is actually a section 14 order, my lord. 2018 matter, I tried contacting it because I did not have the benefit
No,
of
how can
interim
you
order.
question an order of 14 before this court? On what ground?
On the ground that I'm a third party, my lord. I filed an application, that is, there was an agreement for
For
sale
being the
initially.
third party also, you can go before the
17
DRT.
I can invoke, that is, I also tried because I did not have the benefit of interim order. So it kept on today, I tried calling him, but no response.
Might have become
I
influx
must
because
have-
they might have already taken the possession because
Might
18
have
order
taken-
challenge under 2022.
The writ petition is filed by third party seeking the following prayer.
Maybe closed as alternate remedy if at all.
But I'll not grant them the.
Liberty is
benefit of
not required,
14.
my lord. They
Benefit
have an
of 14 that's what,
an
else
observation.
the petition has an effective alternative remedy before the DRT, and the writ petition against order under section 14 is not maintainable. Accordingly, disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Great.
23, Deepak M for petitioner Vignesh Shetty.
No representation for dismissal. You have any instructions?
No instructions.
We should have got instructions.
They're yet to get instructions from the bank.
Yes, dismissal. Tell Mr. Vignesh Shetty, whenever the matters are listed, whether the petition is there or not. Respondent shall submit. Yes,
Serial number 24,
dismissal. No representation for dismissal. Yes,
24 disposed, serial number 25. K. Prasanna Shetty.
It's a matter, my lord, but a small amount is involved, my lord, 13 lakh rupees. But my client, my lord, inquired with the bank. They said, my lord,
is it
they-
the case that you're talking about the other day it has come up and you said about brothers, sisters?
Yeah, please, my lord, it is
Yes,
joint
yes.
family property, my lord. The respondent number 2 has availed a loan.
Hmm.
But though, my lord, he has no capacity to avail a loan in super.
No, are all of you are ready for,
Please, my lord, my lord, the sister is ready to pay the amount, my lord. because,
Entire amount.
Please, the family house is situated. But
no, entire amount sister will pay.
Please.
And who will have the documents?
Because you have got one share in the property, my lord. There are 7
That's
children.
true, that's
Please,
true.
please.
But who will get the documents?
But it will be in
Is the
his
question,
name.
because documents cannot be given to you alone.
Please. Now we have filed a suit for partition and we'll seek, my lord, all other contentions before the, my lord, civil court.
Yes,
In the meanwhile-
Lordship, the other day they have taken time for today saying that they will settle the
No, one
entire
minute.
amount.
No, she will pay the money,
Yes,
entire money. Then to whom you will give the documents?
let them mortgager authorize whom has to give
Huh?
if he is not in station.
What is
Let the
that?
mortgager authorize the concerned whoever is coming up with a power of attorney or an authorization letter which will be identified and we will hand it
Such
over.
time it will be with the bank.
My lordship?
Till such time it will be with the bank.
Yes, my lord.
Come up with an affidavit.
Please, I'll come up with. an
Then
affidavit.
counsel for the
And
petitioner
may I
submits the-
request, my lord, some short time for payment, that I will, my lord, request my friend.
Can
One
be given
week.
without any interim order, my lordship, because this has
No,
been there since
No,
long.
no, 1 week time we will
Yes,
grant.
yes, yes.
Let them come up, that
Yes.
they will dispose it of.
Yes, my lord.
Then counsel for the petitioner submits that the property is a joint family property. And in that, there is a suit also pending between the family members. Now the petitioner is one of the sisters.
Please.
And she is ready to clear the amount to save the property from the auction sale. And an undertaking affidavit will be filed before this court.
Without prejudice to the mortgage.
Then
my lord.
counsel,
Without prejudice to the mortgage created.
without?
Prejudice to the mortgage created, because now they are raising up this issue. When the mortgage was done, this issue was not there. Title was clear. Now they are coming up.
Whatever it is, you're
Yes.
getting your money.
Yes, my lord.
You're getting your money. The land counsel appearing for the respondent bank submits that as far as the release of the documents are concerned. They will, whoever has mortgaged
Yes.
and to them or to their authorized agent only, they can release the mortgage.
Yes.
Be that
Right,
as it may. The petitioner shall come up with an affidavit by which date? Today is
Sixth, my lord.
We'll have it on 15th.
Please.
Yes.
Place this matter on 15th. By that time, the affidavit shall be on record, or else the writ petition will be heard on the merits of the court will pass orders on the merits of the matter.
Could it be on
The-
16th?
Some other writ petition is also there.
My lord, that is disposed of.
That is disposed.
Disposed of.
That was last year, same, on the same lines it is filed.
Interim order is there in this.
No,
No,
my lord.
no, my lord.
Till such time, no coercive steps.
Yes.
But could it be on 16th?
Obliged.
26,
Could it be on
Raju CM.
16th, my lord, instead of
It'll
15th?
come,
16th, my lord, could it be on 16th?
16th.
Please, grateful. Lord.
And on that day, if the affidavit is not
Please,
there, I'm
please.
not going to extend
Please,
interim order and I'm
please.
going to dismiss the writ petition.
Please, please, very
Yes,
Till number 26, Raju CH.
For petitioner, my lord.
yes.
The trial court has a securitization.
Who appeals for Bank of Baroda?
Bank of Baroda. That Vignesh Shetty, Divya Purandar,
We'll have it tomorrow.
Oh,
This is matter tomorrow. Mr.
Wednesday,
Vignesh Shetty is directed to,
Wednesday.
no Wednesday, or else some other council, I'll list this matter tomorrow. Mr. Vignesh Shetty is directed to take notice on behalf of the responding bank. The counsel for the petition serve the copy of the petition and the respondent shall get instructions by tomorrow. List this matter tomorrow. Yes, next.
Till number 27, preliminary hearing B group, 27 urgent, 28. Number 28, M. Veerbhadraya.
Here for the
As per number
petitioner.
2, present, my lord.
I undertake to file NOC Wakalat in the present matter, my lords.
My
My
lord.
lords, the matter in a nutshell is the issue in respect of the present writ petition, my lords, is pending before the Honorable Apex Court. In fact, if my lords could go through order dated 4/10/2023.
Let's see what's the repetition about first.
My lords, a
Call
gift,
for the entire
a
report
gift
from the
deed,
file of the respondent number 1 relating to case number.
my lords, a
That's
gift,
the order dated passed by respondent number 1. Come to the cause
a
title.
gift deed, my lords, a
Come to
gift,
the cause title.
please,
You are the son.
Yes, my
please,
lord.
please. My lords,
He's the father.
yes, my lords, this is a gift
Third
deed,
respondent is the daughter.
please. My lords, if I may request my lords to go to order dated 14/10/2023. 4/10/2023. Same issue, my lords, is yet to be answered by the Honorable Apex Court, which is pending in the case of Jayanti Anil Kumar versus Krishna Marar versus Jayanti Anil Kumar.
What is the issue?
A conditional gift, whether this gift deed was executed with a condition or not, my lords, that is the issue here. This went up before the Senior Citizen Tribunal. There, in fact, the tribunal set aside the order which I have assailed before this honorable court, stating that there was no
But we are
condition.
passing so many orders,
No, my lords,
notwithstanding the fact that.
but it's their own submission, my lords, on 4/10/2023.
Now, we are only concerned with what is the settled law. As of now, what is the law?
But as of now, my lords, the condition is what they say it's existent.
If
But
there is a condition, if there is a, where is the
my only
compilation
request is, my
of,
lords, may
where are the compilation of judgments which he has given the other day?
may I be permitted to come on record, my lords? I'm filing NOC Wakalat. A senior advocate is against
The
this
day
matter.
he has given, you kept it there.
compilation.
He has given a set of judgments on this.
And I doubt about this proportion that, SLP
Huh?
pendency.
It's pending, sir. It's on 10th of August. It's listed on 10th of August. Please check the website, sir. It is pending.
My lord, this matter was filed in the 2019. I am the respondent number 2, father,
Yes.
my lord. But this already 7 years is completed. I am already 75 years age. I am unable to come. They go ask, my prayer before your lordship is to dispose the case on the merit of the case.
That's what.
My lords, may I have it? My lords, in that case, may I have it next week? A senior advocate is engaged in this matter. I'll have to come on record. I have been granted NOC, given NOC in the morning, and that's the reason I'm before your lordships appearing.
No, that is the chance your client is taking.
No.
By giving, and the matter is listed today, if he gives a no objection to another, you should have done it long back, isn't it?
No, my lords, in this case, senior advocate D.R. Ravishankar is engaged. That being the reason we've spoken to him also in the morning. My lords, may I have it next week? My lords, their submission on 4/10, my lords, which they, in fact, when we were ready to argue on 4/10/2023, the party in person comes and he's also an advocate, even the children are also advocates. He comes and submits that the matter is pending before the larger bench. The issue is pending before the larger bench, before the Honorable Apex Court. Now, my lords, that matter is listed on 10th of August 2026 before the Honorable Supreme Court.
Notwithstanding the judgment, whatever, we are not
Please, my lords,
concerned.
my
We are
lords,
only
next week.
concerned with what is the prevail, what
May I
is the.
request Monday, my lords? Monday, my lords, please. Monday. No, my lords, let me come on record, my lords. There is no condition is what I'm trying to say.
Come
my lords,
on
to the
Monday.
court. Please, my lords, great.
Does this matter on Monday? No further adjournments?
Please, my lords.
We'll decide it on Monday.
Gautam Raghunath. Oblige.
Monday is holiday.
Gautam Raghunath.
List on not 15th, on 6th. Take it. 15, list this matter
Copy
on
me served on
16th.
Azhar.
We'll have it on 16th. Come on 16th. Yes.
Till number 29.
My lords, interim order of the case. There's an interim order substitution.
My lord, in 29, my lord, the council, my lord, was on record. My lord is no more. My lord, he has expired. My lord, today, my lord, I may be permitted to file. My lord, I undertake, and if I am permitted to file power, matter may be taken up, my lord, any day next week, my lord.
Now, I'll take it up this matter on 15th.
Please, please,
This petition against L&T Finance.
please, my lord.
The respondent is L&T Finance.
Please,
It's not maintainable in the light of the Supreme Court judgment.
please, please, my lord.
You please examine that also.
Please.
Yes.
15, my lord.
Is assigned to the RC. Even both on RC and L&T, both writ petition is not maintainable. Yes, that day we will see.
Cell number 30, 30 adjourned, 31. Cell number 31.
When
Sunresh.
this type copy has to be filed.
Huh?
A type copy has to be given, office objections.
Where is the office objection?
P. Kumarsamy.
31.
P. Kumarsamy, yeah, that's-
There is no office objection in 31.
That's what I was
PH moved, who has moved the court?
That is.
Without even looking at
No,
the.
I was, what I was instructed is in the last date, it was listed in March. In last date that office objection has not been completed, kindly complete, is what I was directed. P. Kumarsamy, serial number 31. This case, I wasn't instructed like that. I'll look into the matter.
They have moved the memo. You have to look into it, isn't it? Some submission you make saying that office objections when there are no office objections at all. Tomorrow. Tomorrow, no further adjournment.
Lordship's leave, my lord, one submission is serial number 29, my lord. This is an order, my lord, interim order that is subsisting.
If look at it, Mega, if interim order is there extra.
Grateful. Deeply.
Cell number 32. 80 Malia. Cell number
Give the
32.
file. Hmm? No representation for dismissal tomorrow. Yes, 33.
33. Cell number 33. Saraswati.
So, get that mic for them.
Mike sensor.
I'm apology, my lord. My lord, I'm appearing for the respondent number 2 and 3 in this case, my lord. In this, my lord, writ petition is seeking, my lord, the hand over the possession of the flat. Flat has been handed over to the flat has been allotted to them, my lord. Later, they have filed the letter to me, my lord, saying that we are refund the amount. We are not taking the flat. After this, my lord, here they have given a letter. Then here, before this honorable court came and
Representation for the petitioner, counsel for the respondent is present. Does this matter for dismissal tomorrow?
much of this.
Yes, next.
34.
Appearing for petition.
3 and 4, Milad. All the documents are in vernacular, Milad.
Yes, appearing for petition. Mother, respondent number 3 has executed a release deed at annexure A by receiving an amount of rupees 3,80,000.
Senior citizens.
Yes.
Who are you?
So I am the daughters of third respondent's sister.
Third respondent?
Third respondent is uncle of the petitioner. Third respondent and mother of the petitioners are the brothers and sisters.
He is issueless.
Please, please.
Third respondent is issueless.
Issueless.
Now, when was the deed?
Deed was executed on 2/11/2018 by receiving rupees 3,80,000 towards 86,000 towards his share.
3,86,000
towards his share. So, my lord, it is a purely.
What is the land? What is the nature of land?
Site, my lord. residential property.
Residential property,
Yes.
extent?
18 into 25 feet at Shikaripura town, Shumaga district.
Hmm. Then when they have approached the authorities?
That he has approached the authority on 22/1/2022,
Stating that?
stating that they have misleaded him and without his knowledge, this deed has been executed.
Yes, Mr. G.
It's a release deed with consideration. Similar, it's a release deed with consideration. Similar, we will not suppose.
Civil court has to take decision.
53 has no application at all in this case.
I appear for the parents, we are the illiterate, the parents, they are issueless. By misleading them, they have
Take the money.
We have not taken the money, that was what the contention before the.
In that case, that has to be decided by the civil court.
Please, but under 23, it also says gift deed
Let's
or
see.
otherwise, 20.
No, otherwise, what are the, let's see give that act.
It's under the act.
Even then, my lord, if once there is a consideration, it may not possible for us.
No, let her, for her satisfaction, will read 20.
That's 23, where any senior citizen who after the commencement of this act has transferred by way of a gift or otherwise, so.
Next,
the district.
Subject to the
his
condition.
or otherwise, his property subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferee refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud or coercion or undue influence, and shall at the option of the transferor be declared void by the tribunal. This is exactly my contention, that by under the undue influence, they have taken us to the sub-register.
That is not the section says.
Please.
Section says, if any document is executed with the clause that they will take care of their necessities, and if you're not doing so, that amounts to fraud. As it is a fraud, it would be set aside.
Please.
Not like, not if you, all your contentions, what you're saying, that by playing fraud, they got this document executed, no recital with regard to anything, because it is of consideration. According to you, consideration is not paid. That would be decided by civil court.
One contention is that, by the conduct of the parties has to be looked into, when the parents approaches the district magistrate under 23 is what the,
What were you doing from 18 to 22?
18, we were not, 22, we came to picture, only when we got to know that they asked us to go out of the house. That is when we got to know, that a release deed, in the back of us has been executed. By
How the
playing a
amount
fraud.
is paid?
They say it has already been paid even before the execution of the release deed. If I may read, that is in vernacular language. Please.
Unfortunately, that's whatever you're pleading, that can't be decided by them under 23. Now, if the court gives such a finding, then we will be enlarging the scope of this act and the powers of the conferred on them.
Under 23, since being it is a beneficial legislation, this court has the power, under 23 also, the district magistrate had the power to entertain my application is only my
As far
submission.
as the provision 23(1) you have shown, it will not apply to you. Any other
It
provision?
says gift or otherwise, so that is why,
Yes, or otherwise with the clause.
but it does not say whether it is passed under the
You read
consideration
it
or
again.
not.
It says so, you read it again.
Please. Where any citizen who, where any senior citizen who after the commencement of this act has transferred by of gift or otherwise his property subject to the condition that the transfer.
Pause there.
Please.
Has transferred by way of gift or otherwise. So don't read this otherwise in isolation. Gift or otherwise, his property subject to the condition that the transferee shall provide the basic amenities and basic physical needs to the transferor, and such transferor refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud.
Please, the word consideration is not included in this provision.
It is speaking about subject, that is there should be an averment in the said recital.
On that, the coordinate bench has said it need
Division
not
bench
be
has taken the other view. Division
Please
bench
do.
has taken other view. Take that judgment. Please come. Just know the judgments which in the other case given by him. the present writ petition is filed, seeking the following prayer. The facts of the case are the respondent number 3 to 4 are issueless. The petitioners 1 and 2 are none other than the daughters of his sister. Yes,
Sisters of R3.
the daughters of the third respondent. Sisters' daughters.
Sisters' daughters.
Ah.
We were
The
issueless.
petitioners are none other than the daughters of the third respondent, daughters of the third respondent's sister.
Correct.
It is a case that a release deed is executed. It is a case of the third respondent, the third and fourth respondent, that the petitioners by fraudulently pressed into service a release deed, and by virtue of the same, when the respondents are being evicted from the premises, they have approached the which respondent?
Respondent number
Approach respondent number 2.
Respondent number 4. Huh?
2.
Respondent number 2. And the respondent number 2, by order impugned, what did he say?
He set aside, he was, my petition
By
was
order
allowed.
impugned, he has set aside the relinquishment deed dated. What is the date?
Dated.
29
Release deed, by release deed, what is the date?
29/4/2022. Annexure
29/4?
2022. Annexure D.
29/4/2022. Then counsel appearing for the petitioner submits that the second respondent has no such authority to cancel the relinquishment deed. It is submitted that the same is with consideration. The respondents 3 to 4 having received the consultation have relinquished their share in the property. It is submitted that the relinquishment deed, which is followed by consideration, will not fall under section 23 of the Maintenance and Welfare of the Parents and Senior Citizens Act 2007, hereinafter referred to as Act. It is submitted that the second respondent has exercised the jurisdiction, has discharged the duties beyond the powers conferred upon him under the Act. Hence, the order dated.
More
so and so.
submission, my lord. We have filed appeal before the deputy commissioner. That is also
Against
dismissed.
that, and the appeal is filed before which respondent?
First respondent.
R1.
Part. Before the first respondent, and the first respondent has affirmed the order of the second respondent.
The order dated 18/7/2020.
Second respondent, it is submitted that the order passed by respondents 2, which is affirmed by the respondent 1, needs to be set aside, as the same is contrary to section 23. When counsel appearing for the respondents 3 and 4 submits that respondent 3 and 4 are the senior citizens. They have never executed the relinquishment deed. When in the year 2022, when they were forced to vacate the premises, at that point of time, they came to know about the alleged relinquishment deed, and they have filed an application before the second respondent. It is submitted that as per section 23, which refers to the transfer by way of a gift or otherwise, the relinquishment deed falls in the as it is the otherwise, and the provision is silent about the consideration. Whether the consideration is received or not is immaterial. As a fraud has been played on a senior citizen, the respondent 1 and 2 has authority under the provisions of the Act And as per the powers vested in them, they have passed the impugned order whereby the relinquishment deed is set aside. It is submitted that a coordinate bench of this court, whose judgment is that?
I am relying upon.
That is a writ
Justice-
appeal 575.
That you have filed here?
Yes, that also I have filed.
That is just Suraj Govindara's order.
No, that is a single bench judgment.
No. She's saying some.
Yes, the
in-
one
in
that
her
I am
favor.
relying upon is.
So in her favor is which judgment?
The writ appeal judgment.
Is in her favor.
No, that writ appeal is against her.
That's what, where is the single judge's order?
This one, that also I have to do.
That's what I'm saying. Who is the judge?
Suraj Govindara, Honorable
Ah,
Justice.
that's what. When counsel for the respondent had relied on the judgment of the coordinate bench of this court in Venkataya, give it to him. Venkataya versus State of Karnataka, reported in 2026, SCC online, Karnataka 489. She had relied on paragraph number?
Paragraph number 18.3.
Whether an
Page
express recital in the gift deed.
Please.
She relied on paragraph number 18, the entire 18 is 4.4.5, like that, entire 18 you please extract. Relying on this, it is submitted that whether there is any recital or not, the same attracts section 23. And both respondent 1 and 2 had rightly passed the order and no interference is called for. Learned AGA appearing on behalf of the respondents 1 and 2 submits that the order, which the petitioner is relying on in Venkataya's case refers supra is the division bench. Where is that?
Nanjapur State of
one
Karnataka,
minute.
575, writ appeal number. Not right. Not this judgment was taken, earlier judgment.
Not this, not this.
Not
one.
this,
Ah.
not this, not
It is submitted that, in fact, the division bench of this court in case of Nanjappa
Yes, madam.
versus State of Karnataka, arising out of writ appeal number 573 of 2022, has taken a contra view. And the division bench has held that paragraph paragraph number 18, 19, 20, 21. Relying on this, it is submitted that the judgment of the division bench, in view of the judgment of the division bench, unless the document is in consonance with 23, unless there is a recital, the first respondent 1 and shall I record it? No? It is leave it, whatever having after his submission, the court, the second respondent 1 and 2 has passed the order as per the provisions of the Senior Citizens Act. Having heard the counsels on either side, there is a material law record. Before proceeding with the matter, it is appropriate to look at section 23, extract section 23. The learned counsel is relying on the judgment of the learned single judge in Venkataya's case refers to the division bench in case of Nanjappa, so and so, now that you cite here. And at paragraph number so and so. In the light of the law laid down by the division bench of the court and in the light of section 23 of the act, this relinquishment deed, which is obtained by after taking consideration, wouldn't fall under section 23. And the respondent 1 and 2 have no jurisdiction to set aside the same. The contention of the learned counsel, the respondent, that no consideration is passed and no document is executed and a fraud has been placed. Even in that case, the only remedy available to the party is to seek declaration to seek a declaration that the same is null and void, or it is obtained by fraud and coercion before the competent civil court. But under the act, the first and the second respondents cannot decide the same. In that view of the matter, the writ petition is allowed by setting aside the order passed by so and so, so and so. And second point number 2, the respondent is at liberty to avail the appropriate remedy in accordance with law, seeking cancellation of the relinquishment date.
Cell number 35, Gangadhara A.N. Partner, Archana Murthy.
R3 to R6, my lord.
My
R3
lord,
to
sir,
R6. Appearing for respondent 3 to 6.
The matter is settled between the outside the court, my lords.
The matter
The matter is settled between parties between outside the court, my lords.
have settled.
Settled, my lords.
Then give a memo.
Memo on record counsel is out of station. Tomorrow, kindly.
It is submitted that the matter is settled between the parties, and they'll file a memo. This is matter tomorrow. Yes,
Number
next.
38,
37 this is. Yes, 38.
38. Mention the
Give the file.
Lords, in 38, may I please make one submission? Lord? Though I'm not a party, I'll be filing an impleading application. I'm an auction purchaser, my lord. Sale certificate is issued in my favor by my lord Arcil, who is the assignee of the loans. Now, my lord, this writ petition is filed after the auction, challenging the assignment in Arcil's favor without naming me as a party. I only seek your lordship's indulgence, my
No
lord.
representation. You come tomorrow. No representation for dismissal tomorrow.
Cell number 39,
Lord, I am for the petitioner in this matter. Lord, my respectful submission is, Lord, let the state take a considered view on the representation that I have submitted. Last time, Lord, I had submitted that there is threat of displacement and they are not allowing me to complete the house. The house is now completed. I am out of danger.
You said last time like
Lord.
the AG will appear in this.
Yes, my lord. As far as the representation concerned, my lord, there is a larger issue that is under the chief principal secretary, there is a committee is constituted to look into these issues. And insofar as the threat is concerned that he has already constructed, there is no threat as of now. We are not
So I
disturbing.
think
only-
last time I passed some order.
No,
Yes, Lordship.
6/3/25.
Yes.
Then I think you can wait because your case is your client's interest is protected.
Yes, yes. It can be disposed
Then
of
they-
also, my lord. I don't see why it should be kept
No, they
hanging.
want- No. They want some. When do you want?
In the 2 weeks, my lord.
List is matter
Let
after
it
2
be.
weeks.
After some vacations,
vacation.
Lord, anyway, he's
After
good.
vacation.
Grateful.
2 weeks. Cell number 40. Cell number 40,
Lord, this is a matter, Lord, wherein Lord, my party is ready to settle the amount. But since last 3 hearing date, we are requesting the bank, my lord, to give a settlement amount, outstanding amount. Yesterday, my lord, they have issued a letter stating that, my lord, the outstanding amount is 56 lakhs. However, their statement shows, my lord, it is only, my lord, 36 lakh and odd, my lord. But their letter says, my lord, it is 56 lakhs.
Who
And
appears?
In spite of, my lord, the direction from the Honorable Court to
The BS
please
Mahendra.
to issue a consolidated statement, my lord, we have given, my lord, 3-4 request letters and we visited the bank, my lord, many times. But yesterday, my lord, they came to my house and served this letter. And
When is the
I'm
respondent?
ready with the affidavit also, my lord, but
No representation on behalf of the respondent. Counsel for the petitioner is present. Does this matter after vacation? Interim order earlier granted is extended.
cell number 41,
grateful.
41,
My lord, I'm serial number 41.5. It's matter, my lord.
My lord, I appear for 41.1 as respondent. 41.
I will call each matter. So let's first take up 41. Who
I
appears
am
in
appearing for the
41?
respondent in this matter.
Remaining others can be seated. Only 41.
Lords, 41, I appear for the petitioner in this case.
Yes,
Lords, I have filed an NOC in this, my lords.
yes.
Lords, Mr. Ashok, my lords, his name is reflecting in the cause title, my lords. His name may be deleted,
I'll
my lords.
delete his name.
Yes. My lords, in this, my lords, there is a prayer seeking to quash and set aside order dated 4/3/2022.
Ask for the declaratory tribunal. Come to that order. Page number?
Page number 57, my lord. My lords, before that, my lords, page number,
No, we'll read the order and then you can make your submissions.
my lords, this essay is only dismissed based on the delay, my lords, not on the merits. My lords, can I, before I read the order, my lords, can I point out some annexures, my lords? Page number B, my lords. I mean, annexure B, my lords.
What was questioned before the essay?
My lords, sale notice.
Sale notice dated?
Sale notice dated, my lords, 12/10/2017, my lords.
When did you file the essay?
My lords, I have filed it in the year 2020, my lords. There is delay of 45 days, my lords.
No, your lordship.
17 notice.
244 days, my lords. 244 days.
Then?
My lords, can I seek for a passover, my lords?
Because they have already passed an order stating that the tribunal has no power to condone the delay in the light of.
My lords, I'll convince this honorable court, my lords. My lords, in this case, my lords, page number
You will convince the
25
court-
may be looked into.
No, you will convince the court on what point?
My lords, based on the delay as well as on the merits.
But merits will never come into picture now.
My
Only
lords, delay also. My lords, delay
Okay,
also.
what is that you will convince?
My lords, page number 25.
The issue is whether the court has the tribunal has the power to condone the delay.
My lords, that's why, my lords, page number 25 may be looked into for 1 second.
It is not a factual aspect, it is a legal aspect.
My lords, can I make only one submission? Page number 22 of my writ petition may be looked into.
What
22
is
and 25. For 1 second, my lords. Page number 22.
Huh.
My lords, there is a death certificate of Mr. Lakshmikant Shetty. My lords, page number 22.
Okay.
My lords, he was a co-borrower.
Huh.
My lords, page number 22, death certificate of Lakshmikant Shetty. Date of death 15/1/2017. 15/1/2017, my lords. Sale notice is issued on 18/9/2017, in which Lakshmikant Shetty's name has been included. And this sale notice is not at all delivered to me. My lords, page number 25 may be looked at. 22 is the death certificate of Lakshmikant Shetty, co-borrower. And 25, serial number 9.
Property is whose property?
My lords, the property belongs to Lakshmikant Shetty. My lords,
Who are you?
my lords, my lords, now this is a family business, my lords. Lakshmikant Shetty is dead. After that comes legal heirs, my lords. I am few petitioners in this case, my lords. My contention before,
1 minute. He died when?
my lords, 15/1
Died on
2000.
18/9/2017.
No, my lords. He died on 15/1/2017.
Now, once the borrower is no more, you have to start the proceedings
Your
afresh.
lordship, it is a partnership firm, your lordship. The property belongs to the partnership firm, not to the individual.
My lords,
So the partnership firm will continue after the death of the partner also.
That is also revoked, your lordship.
my lords, it is not revoked. It is not revoked.
It is,
It is still there. It is still running. And the other partners are still there. Yes.
he is just a co-borrower, your lordship. He's just a guarantor. And the property doesn't belong to him, your lordship. Lakshmi, kindly pass it over. I'll just get the correct information, your lordship.
Password.
My lord, 41.1, my lord. My lord,
We'll
all
take
these
up,
matters-
yes, 41.1.
Yes, my lord, all these matters are with regard to the limitation, whether condonation of delay can be made or not. My lord, your lordship has already held that condonation of delay is not entertainable. My lord, there is another division bench of this court's judgment, Kailasam's judgment, which also confers the same. My lord, there is another judgment now, my lord, of with regard to Shobha matter, where a division bench of this high court has held, my lord, that condonation of delay can be entertained. Now, my lord,
But there is no Supreme Court judgment on that. Supreme Court
Now there
judgment is there.
Now, my lord, there is a Supreme Court latest judgment, my lord, passed in January. It says that tribunals cannot entertain with regard to limitation. My
So
lord,
we'll follow the, no,
Latest
forget
Supreme
about
Court
the
judgment.
division bench, forget about my judgment. We'll follow the Supreme Court judgment and we'll pass orders.
But my lord, I just had to bring it to your notice. Last time when this matter came up before the coordinate bench, my lord, lordships expressed that another bench, a higher bench is being constituted by this court, but this may not be required to be clubbed. Your lordship will
Not
go on the
required,
basis.
not required because now
Yes, madam.
two division benches have taken a different view and there is a Supreme Court judge. We are not concerned with that.
Yes, my lord.
So
Now,
we will
with
go with the
regard to
Supreme
the
Court
property company limited versus Daddy Mazda, I think my lord is referring to that judgment where it says tribunals can't. I have it.
Judgment your colleague is here.
Your lordship, no, my colleague is not there, my lord. Your lordship may pass over or have it another date. We will
Yes, pass
argue
over,
on
pass over. We'll decide these matters. Pass over.
Number 42.
Petitioner, Lordship. Lord, 41.4, my lord.
41.4, I appear for the petitioners council. Lord, this issue has to be detached from the others because this is on a different ground, my lord. I'll tell your lordship why. My lord, my written statement was not taken on record. So, I mean...
You 41.4.
40 point.
41.5.
4.
4.
41.4 impugned order is at annexure C, page 191.
WP 5301.
Yes.
Yes, where is the impugned order page number?
Page 191, annexure C. At 196, the point for consideration is extracted, my lord.
You have filed
Whether
an IA to set aside the ex parte order
Yes,
and
to
to
set aside
enlarge the
the
time of filing the income statement by a period of 30 days.
correct. Now, the learned my lord tribunal, please look at page 199, refers to an earlier order of the Honorable Supreme Court in re limitation. If your lordship comes to page 199, second line from the top, the defendants have taken a plea of the COVID-19 pandemic issued by the Supreme Court. I have considered the contentions and argument. Supreme Court have considered the situation of difficulties affecting litigants across the country and laid down directions while para 2 of the order dated 8/3/21. Not subsequently, there are orders passed by the court right up to March 22.
What do you
says
say?
that no written statement, Lord. I mean, you get an ex parte
My lord,
decree.
We'll ask him.
your lord's may
Yes.
kindly see page number 6 of my objection statement. In this case, my lord, regard this entire details mentioned. It is not that court they are not interested to file the written statement at all for so many years. And now, my lord, I filed an application for vacation interim order. This honorable court,
OA is
page number
filed
6.
in the year 2020.
No, my lord, this
OA is of the year 2020.
20. The
Yes.
date fell during the relevant period. That is 19/11/25. That is between 15/3/2020 till 14/3/21. The petitioner would be required to file the written statement within 90 days from 15/3/21. That is on or before 15/6/21. The petitioners have not filed the written statement so far, and IFR recall is filed without written statement. That IA has to be filed along with the written statement. Then court would have considered. The petitioners have failed to file the written statement within the time prescribed by the Honorable as per the Honorable High Court Apex Court. Therefore, IA is liable to be rejected. Now, my lord, in this case, now when this 21 case was filed, this Honorable Tribunal has given ample opportunity to file the written statement. IA, they are filing vacation without written statement. Tribunal asked, where is the written statement? No written statement. IA dismissed. Because all these students just to drag the inquiry proceedings. Now the bank, the 1,400 crores they have to pay, not one or two. Now this honorable court, what happened, my lord? While passing this, take into consideration, they have not given any order to stay.
How much, if the court has to consider it on the merits of it, the tribunal, how much time it takes?
How much time?
Time it takes, how much time it takes to the tribunal?
That the written statement was to be filed within 30 days from 27/10/20.
Assuming that if this court set aside this order.
Yes, ma'am.
And permit them to file the written statement, to conclude the OA, how much time it will take?
Evidence under it will take 3 months or 6 months. 3 months, 3 months it will take.
I'll fix
My
that
lord, now, my one is,
what is, there should be, when is this writ petition is filed 24? From the last 2 years, they are enjoying the interim order, isn't it? And still you feel that 3 months time is objection for that. We'll ask them to file the written statement immediately and the OA to be considered and appropriate orders shall be passed within a period of 3 months. It will take it to a logical end. If it gives you any happiness to keep it pending, I'll adjourn it by after vacation.
No, my lord, no. Because this while granting interim order, some amount has to be paid. 1,400 crores spending. So this writ petition and all is dragged on for 4 years.
Interim order is
no interim order. That is what my contention is. Some amount has to be paid without payment to that normal.
Yes, what do you say about the money?
That is what I filed. I for vacation of interim order.
I didn't take the money, my lord. My husband has taken it. He died. He committed suicide because of this extreme pressure from the bank. I am the LRs of the deceased borrower, my lord. I mean, I am the wife and children of the deceased borrower. Some concession, my lord. Give me an opportunity. Let me contest it. Then we will see, my lord.
My lord, in fact, the coordinate bench in the last hearing posted the case only to decide how much amount is paid or continuing or that is the case interim order. Because without normally, my lord, in surplus matters, without payment, that interim order is not there.
Please understand, all these contentions in 2024, not in 2026. Now, for 3 months' time, what are you, now if I adjourn this matter after vacation, it might come after 2 years. So 3 months, let it be decided either ways. If you're entitled, you're entitled, not entitled, not entitled. Let the court decide it. 3 months, you're not losing. No, they're enjoying this blanket order from, and that too it is, if I can understand, that is their OA or their SA. It's your OA, isn't it?
Yes.
They are the defendants in that. Please come. The present writ petition is filed. Certain things, when they are in the interest of the bank, if you yourself, if you have considered on that the bank, some order, some disposal on in 24, by this time you would have got your money. You in the sense bank.
Yes, ma'am.
The present writ petition is filed, seeking the following prayer. The facts of the case are, the petitioner's husband had obtained the loan from the respondent bank.
No, my lord, I was a guarantor. The loan was obtained by somebody else.
Not by your husband.
No, the principal borrower has been discharged by NCLT. I am only a guarantor. He is proceeding against a guarantor. If your lordship looks at page 201, your lordship will see in the NCLT proceedings, annexure F at page 228, my lord. Annexure F at page 228. The principal borrower was admitted to insolvency and
Then what is the bearing of the demise of the husband when you yourself were the guarantor of the property?
My husband was the guarantor. Only factually, your lordship said that my husband took the loan. He didn't take the loan.
Petitioner's husband. No, understood. Petitioner's husband is a guarantor. to the loan that is granted by the respondent bank to the, who is the principal borrower? Second respondent,
Yes.
to the second respondent. It is stated that the petitioner's husband expired on 29/7/2019. For recovery of the said amounts that were granted given to the second respondent, the first respondent bank has filed OA number 524 of 2020 before the DRT. To the said OA, the husband of the petitioner was also was arrayed as defendant number 2. After his death, the petitions are arrayed, were brought on record as defendant numbers 2A, B, and C. Thereafter, petitions are filed I number 182 of 2021 dated 21/2021, seeking enlargement of time to file the written statement, supported by memorandum of facts of the advocate. It is stated that by an order dated 4/12/2021, I number 182 of 2021 dismissed the said order is questioned before this court.
191.
What happened to this order dated 10/3/2021? No, not 10/3/2021. This order dated 4/12/2021 is an impugned order.
Yes. That's the impugned order.
Then you are referring to some other order in the next.
Page 191, that's the impugned order, my lord.
No.
Annexure C. Yes.
No, then you are referring to at
199.
No, 1 minute.
Please look at page 19 of my writ petition. I am asking for setting aside of that order only. And to allow IA 182 of 21.
DRT rejected this and has posted the matter for judgment on 29/2/2024. So this order of 4/12/2021 is questioned in 2024. Is it?
Please, my lord.
What is the petitioner doing from 2021 to 2024?
They also did not do anything. They only led evidence in the matter in 2023, and thereafter it went for further evidence of the plaintiff's bank. And then when the order was
4/12/2021, we cannot accept the fact that they are so ignorant and they don't know anything. They're engaged. They're led by an advocate. 4/12/2021, an order is passed. What are they doing till 2024? The interim order was granted on 21/2/2024. Almost 3 years. By that time, they are parties to the proceedings. And no, not even one reason. Why did they keep quiet? In the entire, please show one amendment in this petition. Why they have not questioned it from 21 to 24?
Lord, what happened was that the principal borrower was admitted to insolvency before the in IBC proceedings before NCLT. And since the resolution professional was appointed in so far as that was concerned, they were paying the money to the bank, my lord. The bank did not take any action against me at all. When the matter went for judgment, my lord, it became evident that notwithstanding the fact that the principal borrower, my lord, had compromised with the bank, my lord, my case became extremely weak because then they will proceed against the guarantor also. Your lordship may just give me an opportunity to contest, my lord. It may be the same thing in the end. But give me some opportunity to have some.
He has to pay something for his lapses. We can't just like that. It is not a simple money. When these were, court can't come to a rescue of a party who is not vigilant and who has no bona fide reasons. Please come up for instructions when he is ready to pay the whatever, some amount, some cost, whatever it is. Just like will not.
I'll take instructions. All that I'm saying is, my lord, 41.4.
This matter dealing from other matters. 41.5 dealing from the other batch. This is matter on 41.5 or 4? 41.4 dealing from the other matters. This is matter on 16th. No further adjournments. Interim order is extended till then.
Your lordship, have it in the week of 23rd, my lord, please. Week of 23rd.
23rd? No further adjournment.
Please, 23rd.
42.
41.5, ma'am.
Who appears in 41.5?
I'm appearing in 41.5, Millards.
Yes.
Plus one, there are two grounds which is raised in this writ petition, Millards. One is with respect to the limitation, which your lordship has already held it. However, now it is referred to the larger bench.
No, but there is a judgment of that's why it's passed over. Please wait. We'll take it up in the
My lord, in this case, my lord, in a previous coordinate bench, my lord, the same argument was addressed.
No. There is a Supreme Court judgment. We'll forget about what division bench, what is happening. No. Even if it is referred, it can't be contrary to the judgment of the Supreme Court.
Yes, my lord.
So that Supreme Court judgment is relying on. We'll look at it in the afternoon and pass orders.
Yes, my lord. Contrary, my lord,
Another ground I'll be raising, Millards.
That I'll hear. Yes.
my lord, in this case, my lord, the similar submission was made in the previous occasion. My lord, the court told that is one aspect. The other aspect is unconditionally you have taken the interim order.
I'll hear it.
Yes,
I'm hearing it on the merits of it in the afternoon.
Yes, ma'am.
Yes.
Cell number 42.
For petition,
Lord, 41.4, could your lordship extend the stay till the next hearing date? 41.4.
Yes, interim order I've already extended. Yes.
Cell number
Grateful.
42. N. Nakaraja.
I appear for petition, your lordship. Petition challenging the validity of the date order passed by Annexure C, your lordship. Second respondent is the sister of the petitioner, your lordship. Third respondent is the father of the
Which
petitioner.
matter you are representing? Which matter you are representing?
42, your lordship.
It's a DRT matter.
Yes, your lordship.
42.
42.
File is correct.
Yes.
To recall the order passed by the debt recovery tribunal.
Final order, your lordship. That is final order. Annexure C.
Dated 28/6/2024.
Yes, your lordship.
Come to that order. Where is it?
Annexure C, your lordship.
Page number.
22, your lordship. Canara Bank filed a OA 971 of 20, your lordship. I filed my return statement and contested the case. The petitioner is a minor.
Where is Divya Purandar? Passover?
Your Lordship, have it 2 weeks time. I have
No,
some.
2 weeks we'll decide it. Yes, 43.
43, Kavita N. 43, Kavita N. for
Here with the
petitioner.
respondent back, my lords. Petitioner is challenging the criminal miscellaneous.
Challenge the?
Section 14 order, my lords. So they have not completed the interim order also.
Interim order also. No representation for dismissal tomorrow.
Case number 44,
Plenty this case, man.
44,
Unfortunately, on record counsel is not feeling well, man. Kindly have it on next week.
This is about a coffee plantation. Is it a crash crop or not a cash crop, Your Lordship?
It's already
Decided. Coffee palm plantation is supposed to be a cash crop.
This is matter finally on Thursday, no further time. Wherever I said no further time, causally should indicate it, inform them.
case number 45,
Look at it, interim order is there extreme in 44. 45,
45, Santosh,
no representation for dismissal.
case number
Tomorrow.
46, 46,
Appearing for petitioner in this case, filing a memo, certain documents in respect of the bank is concerned. There is an outstanding loan of around 3 crores is pending till today. They have not challenged before the DRT, directly came here. The surface.
They have a stay in this.
Please.
There's a stay in this.
There is stay is no further.
Your Honor, on 21/8/2025, the order is passed by this court responding to the request for the interim order, Sri so-and-so, counsel for the first respondent, that's the banker it is,
The file.
submit on instruction that no proceedings have commenced as of today under this Securitization Act for recovery of the amount payable in terms of settlement agreement dated
Come to the
2/11/2022. There's a tri-party agreement, Your Honor.
Come to the writ petition. To accept repayment of outstanding loan as per the settlement agreement dated and restrain the bank from proceeding with the auction, creating third party rights. So where is the settlement agreement?
That is on 2/11/2023,
Page number?
page number 27, Your Honor. Sorry, 23, Your Honor. Annex realities. This is still in force, Your Honor.
No, Your
What are the terms of the settlement agreement? Please look at it. Point out what are the settlement terms of that?
Just on the page number 28, Your Honor, can be looked in. These, para number 17, Your Honor. This agreement cannot be modified, amended, waived, terminated, or supplemented, except in writing or executed by the parties.
What are the terms of the agreement? What you have to pay? When did you pay? Have you adhered to the conditions or not?
No, that's all. Conditions were there, Your Honor.
Where are they? That we will see.
Page number 26.
That's page number 26 onward starts, Your Honor. Page number, para number 1. The borrower agrees to acknowledge the after apportionment of the earnest money 2 crores 25 lakhs, 2 crores 25,000. Here, what happened, Your Honor? On 1/3/2020,
We'll read.
paid by the bidder, then amount of rupees 6 crores 75,000 was due and receivable by the bank. However, before making the balance payment, the bidder approached the borrower for payment of his earnest money and requested them directly settle their dues with the bank. Accordingly, the borrower then approached the
Date
bank.
of this agreement?
Your Honor,
Date of agreement.
2/11/2023. Because this, the respondent, one is violated this court order, Your Honor. There was stay it was. In spite of that, they are auctioned that. Therefore, this tripartite is arised here.
We'll look at this further. The borrower confirmed they have an obligation to pay 8 crores.
Yes.
On or before
So I'm
30
ready to-
working days. 30 working days from when? That is from 2/11/2023.
Yes, Your Honor.
30 working days.
Yes.
Let's take it to 15th, let's say 15/12/2023. Did you pay the money?
No, thereafter, because of company issue, the petitioners were arrested by the Gwalior branch, crime branch in 1/4/2024 it is. Thereafter,
Are they concerned with that?
that's it, you all informed it to the bankers also.
No. How are they concerned with whatsoever happens to you?
No,
As per the agreement, when you're reading one condition of the agreement, other condition is binding on you. Amount of 8 crores, you have to pay within 30 days.
Yes.
You fail to pay. Now that agreement is no more in existence.
No, I am willing to settle the agreement, whatever the type of
But doing
agreement,
it,
today also.
When is this writ petition filed? 2025.
Yes,
On 7/8/2025.
yes.
Why should we tell them? That is not the business of the High Court to tell that. If there is a settlement, if you have failed to honor it, that's for them to take a call. No, we will not tell them to, accept your payment. Why will this court tell?
No, anyway, whatever the tripartite agreement will follow, they also should follow, because tripartite agreement it is.
Specific
So
performance.
that is what there are some judgments are there, Your Honor.
No judgments. You tell the court.
No, wait, see.
You have to pay the amount within 30 days. Why you have not paid? And why should there be a direction?
Why I have not paid is also mentioned, Your Honor, in the petition. It is there very clearly. I was arrested by the Gwalior crime branch it is. I was there for one year. I released only 9/5/2025. Because there's some company issue, they have been arrested. This is informed to them also. Immediately after coming from that.
Violation of the condition number 1, that you have to pay the amount within 30 days. When once it is violated, there is nothing to be enforced now.
No, at least they should inform me.
Who should
The
inform
banker
you?
should, if that is whether the agreement is cancelled or not cancelled.
Yes.
Nothing is informed. And we were approaching the bank also, they are not responded. Therefore, we are before this court to direct the bankers as per the agreement, I am ready to pay.
Yes.
Before filing of the suit only, the auction has been made, Your Honor. As per the section 14(2), application has been filed before the magistrate and it has been confirmed. And after that, the auction has been given, so the same person has been auctioned, a purchaser, and bid the auction, and he has a successful bidder.
When was the auction?
Auction is on, Your Worship. On 7/3/25 is confirmed, auction.
Auction was conducted on 7/3/2025.
And it is confirmed by the magistrate. Your Honor.
What is
Magistrate, under
confirmation of the
14(2), section 14(2), Your Honor.
It is not confirming the auction 14.
The order has been passed for the auction, Your Worship, and it has been registered. Sale certificate was issued on
It's a Securitization Act.
sale certificate was issued on 24/6/25 itself.
That is not section 14 what you're saying.
After getting the permission from the magistrate
For
court,
taking possession of the property.
taken possession of the property. And it has been
When was the sale certificate is issued?
24/6/25. Your Honor.
When is the writ petition filed?
In August 25.
Now, while conducting the auction notice and at all these steps, have you issued notice to the?
Please, and that has been published in the newspaper also.
Yes, by the time you have come before the court, everything is concluded.
No, Your Honor. Notice is not issued to me. Amended section 13(8) of the act. It is to be noticed again because there is tri-party agreement. That should be terminated or that should be modified. Nothing has been done.
Go to the tribunal and agitate all these issues. Come. The present writ petition.
And my value of the property is 14 crores, Your Honor.
All agitate all this before the tribunal. The writ petition is filed seeking the following prayer. It is a case of the writ petitioner that there was an agreement between the bank and the petitioner, a settlement agreement dated 2nd November 2023. As per the said agreement, the petitioner has to pay an amount of rupees 8 crores 1 lakh on or before 30 working days from the date of the agreement, being the settlement amount towards full and final settlement of the total outstanding amount to be paid to the bank. It is submitted that the petitioner was arrested, and for a period of 1 year he is not in a position to pay the amount in view of the same. It is a case of the bank without any notice to the petitioner, without setting aside the tripartite agreement, without intimation, has conducted the auction. He has relied on paragraph number, the agreement, the clause number 17 of the agreement, stating that the agreement cannot be modified, amended, waived, terminated, or supplemented except in writing and executed by the parties. According to the petitioner, the petition is ready to pay the amount and settle the same with the bank, and there shall be a direction to the respondent. Land counsel appearing for the respondent submits that an order under section 14 of the Surface Act was passed on
17/3/25. 7/3/25.
is passed on 7/3/2025. Auction was conducted and sale certificate was issued
On 24/6/25.
on 24/6/2025, and the writ petition is filed on 7/8/2025. According to the land counsel for the respondent, they have issued the notice to the petitioner and they have followed all the procedure. Land counsel appearing for the petitioner, in response to that, land counsel appearing for the petitioner submits that they have not issued any notice contrary to the act and the rules, contrary to the Surface Act and the rules. Next para, having heard the counsels on either side, peruse the material on record. This court has perused the agreement, the settlement entered into between the parties. As per the settlement, an amount of rupees 8 crores 1 lakh has to be paid within 30 working days. According to the petitioner, because he was in some other issue, he was arrested, he could not pay the amount and there was no communication between the bank. When the bank has initiated the proceedings and a sale notice was issued, and by the time the petition is filed, the auction itself was confirmed. This court cannot entertain a writ petition of this nature. The auction purchaser also is not a made party to these proceedings. The moment the sale certificate the moment the auction notice is issued, the petitioner's right to redemption, the right of redemption is not available to the petitioner in the light of the settled law. The settled law, and that apart, the petitioner has an effective alternative remedy before the debt recovery tribunal. On all these counts, this court is not inclined to entertain the writ petition. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. Petitioner shall have the benefit of section 14 of the Limitation Act. Yes.
Serial number
Lord, with
58
kind
and
permission, Lord.
CL number 53. Last occasion, this court has directed my learned friend to serve the copy of the survey report. Today morning has served not copy. There is a legal lacunas in that, my lord. I have filed my objection, seeking for a week's time, my lord. Today morning, they serve the copy, my lord.
But unfortunately, no things like this are 57.
Yeah, now only they, my lord. Unfortunately, no mentioning at this time. Madam 53 ನಮ್ದು. ಮೇಡಮ್ 53 ಏನ್ ಮಾಡಿದ್ರಿ? ಹ್ಮ್? 2:30
ಇಲ್ಲ ಅಂದ್ರೆ ಓಕೆ ಕೇಳ್ತೀನಿ, ಹೋಗ್ಬೇಕು ನಾನು ಚೇಂಬರ್ಗೆ.
53 ನಲ್ಲಿ ಈಗ ಸರ್ವ್ ಮಾಡಿದಾರೆ, ಅವರು ಇಲ್ಲೇ ಇದ್ದಾರೆ. ಯಾಕಂದ್ರೆ ಒಂದು 12:30ಗೆಲ್ಲ ಕೊಟ್ಟಿತ್ತು, 12:30 ಒಂದು ಚೇಂಬರ್ ಹೋಗಿ ಹೇಳ್ತಾರೆ, ಅದಕ್ಕೆ ಕೇಳ್ತಾರೆ. 53
ಅದನ್ನೇ ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದು ಜಸ್ಟ್
ಈಗ 12:30 ಕೊಟ್ಟರು ಕಾಪಿನ ನನ್ಗೆ.
ಅದೊಂದು ನೋಟ್ ಮಾಡ್ಕೊಂಡಿಲ್ಲ, ಇಲ್ಲಿ ಕಮ್ ಟು ಚೇಂಬರ್ ಬೇಗ.
Continue the list.
Continue.
Yes.
Cell number 46. 47, cell number 46 is 47.
47.
Respondent, finance man.
Peter K.
Appearing for the petitioner, my lord, the order dated 23/10/25, may kindly be looked in. My contention was that
Order dated
23/10. I submitted representation. They have not given me any answer. They are not telling me anything. I
No.
said that you give me a.
1 minute, 1
Yes.
minute. The respondent is a private asset reconstruction company.
This Surface Act is not applicable in view of Annexure E. This is a private lender. He cannot,
It is applicable to them, but it is not maintainable before this court. for
because
you
of
to-
limit.
Not limit. You can't question this before this court. Go to the DRT. Come.
No, my lord, the kindly see Annexure E and then your last decide.
Yes,
Annexure E.
yes.
In exercise of powers conferred under subsection 4, so and so, securitization recommendation, reconstruction of financial assets and enforcement security act, central government hereby specifies the following non-banking financial companies which are
Fine,
covered.
only till annexure C, there is no E. Page number?
16.
Yes,
Non-banking financial companies which are covered under class F and 45(1) of Reserve Bank of India Act 1934 and registered with the Reserve Bank of India having asset of 500 crores rupees above as per their audit.
your respondent is not notified?
No.
But
They,
subsequent notifications I have produced, my lord. It is in the file.
It is notified.
Please, my lord. It is notified and outstanding about 20 lakhs surface is attracted. Earlier it was 1 crore, then it is brought out to 50 lakhs, then it is 20 lakhs.
even that
Subsequent
those
notification is on
amendment,
record.
my lord, this annexure E says the principal amount of rupees 1 crore. My friend says it is reduced to 50 lakhs and then 20 lakhs. By reading of this, my lord, the principal amount should be 20 lakhs. In my case, it's only 12 lakhs. They cannot apply even that latest notification also. That was a question
As on
put him.
Outstanding amount.
As on date, it is, as on today, my lord, it is
No,
25
not
lakhs,
as
58.
today. As on the proceedings are initiated.
Lord, it
12
has
lakhs.
been taken over, my lord, when the surface was initiated, it was about 20 lakhs, my lord, outstanding. Then only
My lord,
the
outstanding is
surface has been
different.
initiated.
My lord, as per notification, our principal amount should be 1 crore. That is reduced to 50 lakhs. That is reduced to 20 lakh. Principal amount is to be taken into account, not the outstanding. As per notification, annexure E, the secured debt with the principal amount of rupees 1 crore. Principal debt
Where do you
amount,
get that?
my lord,
Where do you get it?
page number 16,
Yes,
at the last line,
yes.
secured interest which is obtained by securing repayment of secured debt with the principal amount of rupees 1 crore and above. If it is 1 crore principal amount due for these companies, yes, they can come and file a case, proceed under Surface Act. My friend says,
So, no. Do you accept that fact that this notification is where the principal amount is initially it was 1 crore? You say, then later it has come down till
50 lakhs, 20
The
lakhs.
Principal amount 20 lakhs.
20 lakhs.
Is it correct?
Lord, I have to
take instruction on that, my lord.
Please take
Produce
instruction.
objections, my lord. Kindly have day after tomorrow.
Though
my
I'm
lord.
not entertaining the writ petition.
Please, my lord.
When you have invoked it without any basis, instead of sending it, I will,
Day after tomorrow.
this is matter day after tomorrow, by the time the council respondent by, shall get specific instructions. Yes.
So 48, PP Muttana. 48, P Anand.
Yes.
Appear for the respondent number 3 in this matter.
Yes, Mr.
My-
Muthanna.
My lord, this writ petition is filed against the sub-register officer mainly because
Why it is adjourned on the last occasion?
for producing the citations. I produced citation, my lord.
Take that. Give him also a copy. So now what do you want the registrar to
My
reflect
lord,
that?
this, now
The
my
bank
lord,
has a first charge over the property.
yes, because my first charge, my lord, because now I produced
For
about,
example, if it is not mentioned, what will happen?
no, that because now nobody will come for auction because auction is second time they bid the auction because they will go and see because there is an entry of that agreement of sale. This mortgage was in the 2015. After 2 years, agreement of sale was there. That has been entered. Mortgage by way of deposit of title it is because it is not registered. Now, my lord, now that sale, that is agreement of sale is there. Now that property was sold and that person bidder then auctioned and he came.
Okay.
Now, my lord, that there are several 6 judgments are there.
You say?
Lord, what has happened, Lord? Lord, the loan was of the year 2013. The loan was sanctioned by petitioner bank in favor of respondent 1 in the year 2013. Lord. The property of respondent number 2 was, my lord, given as a security. It was not, my lord, registered mortgage was not done. They are not registered the mortgage. But in the year 2015, my lord, the respondent 3, my lord, being a bona fide purchaser for consideration, Lord, he entered into an agreement. Lord, that agreement is registered for a consideration.
Have you verified the title?
Yes, my lord,
document?
because that is not registered. It is not, entry is not there in the encumbrance certificate. If that mortgage is registered in favor of the petitioner bank, then my lord, the entry would be
No,
reflected in the encumbrance.
Where are the original documents?
Original document, my lord, in the agreement stage, they will get.
You won't even verify anything.
Lord,
about
we
the
have
title.
verified all the certified copies and the photocopies of the documents which they furnished. Lord, having satisfied with the title, my lord, we entered into a sale agreement. 10 lakhs, my lord, advance was given to the respondent number 2, who's the owner of the property.
So whatever it is, the first charges to the bank because
But
mortgage
my
is.
lord, he is indirectly seeking for, my lord, a relief under section 31, which can be granted by the civil court.
No, no, my
He is
lord.
asking for a deletion of a sale agreement,
No, no,
entry
no,
of
no
the
deletion.
deletion of the sale agreement.
No deletion.
Or the
No,
entered in.
they will only clarify, first is the mortgage, second is the agreement of
My lord,
sale.
that kind of a relief, my lord, lordship may
No,
kind
what
of-
will happen? It is a fact.
My lord, it is a fact.
No,
but,
no,
my lord,
mortgage is first, agreement
Lord,
of sale is second.
my lord,
Let that be reflected
Lord,
in the.
sub-register can make an entry based on, my lord, the execution of the documents. There's no document is executed in favor of the petitioner as of date. But, making an entry saying that it's a first.
Is it, do you deny the fact? Or
No,
your vendor
no,
denies
no,
the
as
fact?
per the document, my lord, my vendor is no more, my lord, he passed away. He filed a memo, my lord, seeking deletion of his name. He's not there. He passed away. Second respondent, he passed away. my lord.
Well, then what happened to the agreement of sale of yours?
Agreement of sale is still subsisting. my lord.
You have not filed any suit for
Lord,
specific.
legal is nothing, my lord. We are unable to trace
When was the agreement of sale?
2015, my lord. 2013 loan is sanctioned. 2015 agreement is.
So you have not sought for specific performance, no efforts are made till 2025.
Lord, we have sought for, my lord, we are, we're in a oral conciliation negotiation with the second respondent. He also passed away, my lord. We are tracing, my lord, the legal is not filed a suit.
Please come to these judgments.
My lord, now recent judgment of my lord, division bench of the Honorable High Court of Ernakulam, Kerala, Canara Bank versus this. Here, my lord, that I just take, my lord, that order.
Copy, please.
This page number, my lord, that.
No, at second judgment, paragraph number 5, they have extracted 26E. Read 26E.
Priority to secured creditors. Notwithstanding anything contained in any other law for the timing in force after the registration of the security interest.
Whether it is registered,
Page number, my lord?
whether it is registered.
Registered.
Which?
Registered.
No, ours is that security interest has been created, registered because that.
No, according to him, it is not registered.
No, my lord, security interest because now that mortgage by deposit of title deeds, it need not be registered. And no banks are registered because only original documents has to be deposited before the bank and bank will get there to register. But sub-register office, it is not registered, means it will not reflect it. But the deposit of title deeds, it need not be registered at all. And the property and the transfer of property act, registration act also said it need not be registered. In fact, no banks are registering the deposit of title deeds.
No, what is this? What does this mean?
No, this
I'm
is my
looking at
lord,
the
wherever
provision.
security interest has been created and registered security interest, registration of security interest. There are two interests. One is bank is taking deposit and they are registered under that, under the act, registration act.
26E is referring to registration of security interest.
Yes, madam.
I'm only asking you that.
Yes, madam.
So 26E speaks about the rights of the secured creditor, where in case of registration of the security interest.
Yes, madam. Now, that is what I'm telling my lord, this EM, wherever mortgage is given by EM, it is not registered.
No, what is the procedure and all? I'm not asking on that. The Karnataka, what is this, which I quote is Madras High Court.
Madras High Court.
Has relied on 26E.
Yes, madam.
To pass this order that there is a priority to the secured creditors. So what is the priority? Notwithstanding anything contained in any other law, after the registration of the security interest, the debts due to any secured creditor shall be paid in priority over all other debts. And all relevant taxes are so and so, so and so. After registration of the security interest, there is a comma.
Yes, madam.
What is it your friend is
Hello,
saying?
he says Surface Act, Surface Act, 26E is a Surface Act. And the Surface Act 26 is that your lordship.
That's what I'm saying, 26 is Surface Act.
Yes, my lord. That is Surface Act. But that RDB Act is different clause is there, section 34.
Let's see that. This judgment you are relying on is dealing with 26E of the Surface Act.
Yes, ma'am.
And pass this order. So now let's read the RDB Act. Where is it? Let's read. Which provision?
34, 35.
35.
34 and 35.
Let's read it.
This may kind of taken end of the list, my lord.
Act will to act to overriding effect. What is the relevancy of this?
35, my lord. My lord, that's been taken up in the end of the list, my lord. I'll get the book. In fact, the book is there in other file. End of the list, my lord.
Yes,
Need not
end
be
of the
adjourned, my
list.
lord.
End of the list. Yes, next.
Case number 49. Rajaram is for petitioner. Vinay Bhatt.
In this case, my lord, petitioner has remitted 50% of the deposited amount, my lord. Commission may be given to arrive at a OTS. Fixed time may be granted, my
1
lord.
minute, 1 minute. Your question, the sale notice issued by the
my lord.
respondent.
Please, my lord, in this case, my lord,
Why have you questioned the sale notice? What is the reason? What are the legal grounds?
because after.
What is that?
My lord, on 18/12/2025, this honorable court granted an interim order for the 50% of the deposit, lordship. The first writ petition was challenging the possession notice. It was stay had been granted. On 18/12, before the stay was granted, the sale notice was issued. Since he paid the entire 50%, with his consent, the account had been upgraded and sale notice had been recalled because we don't want to proceed with them. That is the undertaken.
So no surface proceedings
There is
are
nothing. That is the thing we told that matter can kindly be. If it made a default, we should have the liberty and they should have the liberty to challenge those actions. If they made a default in future again, then we have the liberty to proceed with them and they have the liberty to challenge the same thing.
Commission may be given to arrive at a OTS, my lord.
That cannot be.
Now your account is regularized, nothing is there.
Please, my lord,
Then why are you asking for time in the morning for 1 week?
to argue the matter, my senior.
The present both the writ petitions are filed. WP 1417/2026 is filed seeking the following relief. WP 37611 of 2025 is filed seeking the following relief. The land counsel appearing on behalf of the respondent placed before this court a communication dated 19 January 2026 as per the same.
It was not
The
a
sale deed, the sale deed.
sale note. That is
Sale
the
notice along with position notice is recalled. Sale is cancelled as accounts are regularized. It is submitted that as of now, it is submitted that as no proceedings on the Surface Act are pending and the account is regularized, nothing survives for consideration in this writ petition. Accordingly, the writ petition is disposed of. The writ petition is dismissed as instructions as a loan account is regularized.
Much of it.
Yes.
Say number 50.
Lordship, sir, for the petition challenging the lordship, the action of the bank, your lordship, where the property which was bought on auction was already sold, your lordship, before the rate of auction by the borrower itself. As per the
You're the auction purchaser.
auction purchaser, your lordships.
When was the auction conducted?
On 4/12/2026, your lordship. Sorry.
4/12?
5/12/2025, your lordships. And on 4/12, your lordships, I deposit 10% of EMD amount, 10 lakh rupees. And your lordship, as per the sale intimation, your lordships, I deposited another 32 lakh rupees on 5/12.
That is 25%.
25%.
15%.
Yes. And I was supposed to deposit the entire amount by 20th of December, your lordships.
20th of?
December. Now, your lordships, on 16th, your lordships, I came to know that, your lordship, there's an increment of the property where the property was sold by the borrower on 2nd December itself.
3 days before the auction.
3 days before the auction date. And so, lordships, I wrote to the bank informing that, your lordship, the property has already been sold. Your lordship, and the bank is not in the position to even sell the property to me. Hence, I sought for the refund of the money, your lordships. That the bank, your lordships, initially refused, your lordship. Thereafter, we issued an intimation annexure A, your lordship, saying that, your lordship, they are going to forfeit my amount.
Yes, my lordship, presently the property is sold one after the this auction did not conclude because the 75% of the balance amount has not been paid. The bank has proceeded further.
What do you say about this encumbrance? A property
My
that is
lordship,
already sold, how can that be resold?
My lordship, the submission is this encumbrance what he has created is without the consent of the bank. Bank has initiated the surface proceedings much before that and just 2 days before the auction date. That is on 2nd December 2012.
Whatever it is, why will he enter into a litigation? Why will he take that, you have to return the amount? How can you forfeit?
Yes, ma'am.
I'll leave it to the court. My function is
Forfeit, return the amount. The present writ petition is filed. Seeking the following prayer. It is a petitioner
Yes.
has participated. You want to say anything?
No, my lord. Yes.
The petitioner has participated in the auction conducted with the respondent bank on 5/12/2025. The petitioner was declared as a successful bidder, and accordingly, the intimation letter was issued to the petitioner on 5/12/2025 at about 4 p.m. The total bid was 1,68,33,000. And the petitioner was directed to deposit 25% of the EMD amount within one working day, and balance of rupees 31,74,950 and EMD of rupees 10,33,300. Accordingly, as per the mandate, 25% of the bid amount was deposited by the petitioner on 6/12/2025. And in all, the petitioner has deposited a sum of rupees 42,08,250. Further, the balance of rupees 1,26,24,750 was to be paid by the petitioner within 15 days, that is on or before 20/12/2025, at the concerned branch of the bank. While the thing stood thus, the petitioner has got an anonymous call informing that the property in question has been transacted by the owner on 2/12/2025 itself. Upon verification, the petitioner found that the property was in fact sold by the borrower in favor of one K.M. Shivakumar by way of a sale deed dated 2/12/2025. The petitioner has also applied for the encumbrance of the property and found the transaction of the said date. Immediately, petitioner has approached the bank and informed the bank about the sale transaction. Though the bank showed unawareness of the said, though the bank showed the ignorance of the said transaction at that point, it was learned by the petitioner that in pursuance of the said information, the bank has initiated the criminal proceedings against the borrower, and an FIR was also registered in the jurisdictional police station. The petitioner has sought the refund of the amount, but the respondent bank expressed its inability to refund the money, intimating that there exists Supreme Court guidelines barring refund of the EMD amount. The petitioner has addressed a letter dated 19/12/2025 expressing his intention of withdrawing from the bid since the bank is no more in a position to transact or sell the property in his favor due to the transaction that took place on 2/12/2025 and sought for refund of the amount. Petitioner has made a detailed representation on 8/1/2026. But instead of considering his representation, the respondent bank issued another notice dated 9/1/2026, which was received by the petitioner on 15/1/2026, calling upon the petitioner to deposit the balance bid amount by 16/1/2026, and in failure of which the amount already deposited by the petitioner will be forfeited without any notice. Agreed with the same, the petitioner has come before this court. Land counsel appearing for the petitioner submits that the auction was scheduled to be held on 5/12/2025 and the property was already sold on 2/12/2025 by the borrower. It is submitted that that as on the date of auction itself, third party rights have already accrued. In those circumstances, when the petitioner was no more interested to go ahead with the auction process and wanted the amount to be refunded, but the respondent back without considering all this, have issued the notice that they will forfeit the deposit amount. It is, when council submits that when the bank is conducting the auction and when the property itself is sold, even before the date of auction, the petitioner cannot be compelled to complete the auction process, and the Supreme Court guidelines with regard to refund of the amount will not come in the way of the bank in refunding the amount to the petitioner in a peculiar facts and circumstances of this nature. It is submitted that the action of the respondent bank in not returning the money is arbitrary, and not refunding the amount and also threatening to forfeit the amount is arbitrary and illegal. Next paragraph. When counsel appearing for the respondent bank submits that counsel appearing for the respondent bank does not dispute the fact that the property is sold by the borrower. However, it is submitted by the land counsel that is not within the knowledge of the bank. About the criminal proceedings also, shall I record?
Yes.
It is submitted that in fact they have initiated the criminal proceedings against the borrower for selling the property.
Yes, and surface proceedings were initiated much earlier to this time.
It is submitted that the surface proceedings were initiated much prior to the sale and after the auction
And such
notice
sale is also void under section 1313 of the Surface Act.
after the auction notice is issued, the property is sold. At this stage, they cannot return the EMD amount, and the petitioner has, as he failed to pay the entire amount, they have they have issued the notice that the amount will be forfeited. After that, what happened?
We have issued a fresh sale notice, and the property is sold, and one of the purchaser of that property is purchaser here, the person who has sold one of the properties.
How can you issue another
My
notification?
lordship, that section 1313 clearly says, irrespective of whatever the incomes which are after the mortgage, we can go ahead and sell the property, and all that.
You have to intimate to the party.
That was not known to us, my lordship. It is
Now in
just
the second
before-
auction, you have, because you have sold to
Yes.
the same party.
No, subsequently the same party has purchased. Now it is within his knowledge.
That is submitted. Then what is the difficulty in giving their amount back? You
No.
will have two transactions now.
It was sub judice, madam. My lordship, this property writ petition has came to be filed.
No, why should you create the litigation? Bank can be fair enough. You could have
lordship,
given back his amount.
The procedural aspect, because of the certain settled position of law, and also under
No,
1313.
Honorable Apex Court never said that you keep the money and the property is with somebody else. You keep the deeds and don't give them the position of the property. And don't give
My
them
lordship, my
back the
humble
refund.
submission is, if that is taken at the bank's end, and it will become a precedent for every such borrower who will
No,
take
no.
up and they
What
will
happens
create an
is,
encumbrance. Yes.
the whatever reliance you are placing on 1313 of the Surface Act, it will come to your case in case of any charge over the property. But here, it is your duty to inform any borrower that they will be doing it at their stake. When
We
you
will
are
take
aware of the litigation, it should be brought to the
Yes,
notice.
well taken, my
When it is not there in either your notice or their notice, which has came out subsequently, they are entitled for the amount.
Yes, my lordship.
What did you write? They'll forfeit the same. It is submitted that the petitions are not entitled for refund of the amount. Next paragraph. Having heard the counsels on either side, peruse the material on record. Admittedly, the auction has taken place on 5/12/2025 and the property was sold on 2/12/2025. The submission of the learned counsel for the respondent bank, this court is not able to appreciate for the reason when there is a dispute even before the property is put to auction, whether it is after the notification but before the auction, and they cannot compel the purchaser to buy the property, which is where the third party rights have accrued, and they can't make they can't the having known the fact the property is already sold and third party rights have accrued, nobody will come forward to participate in the auction. The submission that it is contrary to the order, the law laid down with the Supreme Court about the returning of the EMD or forfeiting of the EMD. That all depends upon the facts and circumstances of the case. In this case, it's a clear case where the where the auction purchaser is entitled for the refund of the amount. Furthermore, in this case, the bank has gone ahead and put the property to auction, and the person in whose favor the borrower has sold the property has participated in the auction, and the sale certificate was issued to him.
I'm yet to get confirmation on that, my lord. So it is.
And he has
it is
participated.
participated.
And it is confirmed in his favor.
Yet to get this information, my lord. I'll take instructions specifically
He
on
has,
that. Let it
he
be
has
participated.
participated in the auction in these circumstances. It is not open for the bank to say that the petitioner's amount has been forfeited and he cannot be forfeited and is not entitled for the refund of the amount. The bank cannot compel the petitioner to conclude a transaction where after the auction notification is issued, third party rights have accrued. In the considered opinion of this court, the concern of the petitioner is genuine and he is entitled for refund of the amount. Accordingly, the writ petition is disposed of. Accordingly, this court is passing the following order. The writ petition is allowed, directing the respondent bank to return the amount paid by the petitioner within 4 weeks from the date of receipt of the copy of the order, accordingly disposed of.
My lordship,
Bank will be directed
50.1
to-
also similar case.
Huh?
Similar
One connected matter is there.
Hmm.
Same, it's in the common auction, same thing as that.
Can be a common order.
Yes.
So will be directed to pay some interest on the portion, interest on the amount of
50 is filed so and so. 50.1 is filed seeking this so and so prayer. In this case, how much in the second matter paid? Dates and all are also same.
25% of 24 lakh 15,750.
24 lakhs.
Yes,
15.
date or same, your lordships. Dates are same.
Huh?
Dates are same.
All the dates are
all
same.
24 lakhs.
Amount is different, your lordships.
Hmm.
So it's 24 lakh 15,750.
Where do you get it in your
Lordship, Annexure
petition?
C, your lordships, page number 22.
Huh?
Annexure C.
No, not an exile in your facts. In this also,
Para number 7.
the
your lordships.
petitioner has participated in the auction. He has become the highest bidder and he had paid an amount of rupees 24 lakh 15,750. After that, he came to know that the property, the borrower, same borrower,
Yes, and borrower is same.
the borrower has sold the property in favor of a third party on 2/12/2025. What you do is the facts of that case in one. Facts of this case is simple. Then the submissions and all are same. Yes.
Submission, your
Then
lordships.
also allowed refund.
Submission, your lordships. Kindly bank be directed to issue some interest on the amount, your lordships. We have been following up with the bank from last 4
From
months.
12 till what is the interest?
Whatever is the period that is retained with the bank, deposit rate of interest applicable.
How much?
That depends, madam, my lordship, that 10 days, 15 days, some clause is
So
there.
what did you say? Rate of interest.
Rate
I'm
of
saying.
interest applicable for the period. Deposit is retained with the bank. Like if it is 25 days, whatever the rate applicable as per the bank norms, that will be paid.
As per the banking norms, the respondent shall pay the interest for the period. The amount is retained by the bank.
Yes, as applicable for the norms of the bank.
I said that as applicable. Yes, that is number. Yes, next.
51,
So,
MFA matters, give the dates.
17.
Yes,
17/4.
yes.
Cell number 53. Fire sub.
We are for petitioner in this case, Lord. Lord, in this case, in the last occasion, this court has directed my learned friend to serve the copy of the survey report. Today morning, Lord, around 12:30, they served the copy, Lord. Say that this survey is also not in accordance with the direction issued by this honorable court. I'll file my objections to this, Lord. Seeking for 2 weeks.
When is that order?
That 18/3 is the order, Lord. This court has directed my learned friend to serve the copy and posted this matter today. First order is the 19
This
to.
court by order date, the coordinate bench of this court by order dated 19/2/2026 has directed the respondent to conduct the auction, to conduct the survey. It is submitted by the land council, the petitioner, that the survey report is placed before the, is served today morning. And it is a submission that the survey report is not in accordance with the, is not
Directions of this
conducted as per the order passed by this court, and the petitioner wants to file his objections. This is matter when,
2 weeks time, Lord, because.
yes, CJ can go after vacation.
Yes. Yes.
This is matter after vacation, and by the time the objection shall be placed on record.
Achabali.
Yes.
Cell number 54.
Here for the
Arun
respondent.
Raj.
Petitioner. Well, I understand your lordship had said, how is it? I inquired. It seems that he moved a memo on Wednesday. It was directed to be posted on Thursday. Didn't get posted. It got posted today because there was an order and stay was vacated and arrest warrant had been issued. This is the instruction I got, so I thought I should clarify. My lord, in this case, what has happened is, one, there is an order to pay maintenance. I didn't pay it in time. Instead of 10 lakhs, I have now paid 15 lakhs. But my submission is this. I have totally paid 62 lakhs so far. Out of about 96 lakhs. Amount due is about 35 lakhs. There is one other mitigating circumstance. The daughter attained majority in April of 2024, which means from that date, maintenance for her would stop and she would have to move a fresh petition with whatever grounds you got. The balance would be about 25 lakhs. Even assuming a balance would be about 25 lakhs. On top of that, my lord, they have got an order in the MC case, section 24 for 30 lakhs. He's trying to pay here, he gets an order that he is unable to pay. He's had a series of medical setbacks. How far it is true, I don't know, but medical setbacks. His speech is slurring, he's not able to move properly. In those circumstances, I'll subject to whatever your lordship may recall the warrant for his arrest, at least the pressure goes on and we can try and negotiate some sort of a settlement with them and sort this out.
My lords, insofar as the MC order is concerned, my lords, on the last date of hearing, the learned senior advocate in fact had submitted that let that writ petition be allowed. I will withdraw my writ petition. Let the writ petition be allowed because we are not pressing on that order because in view of the fact that the apex court has held that you only an amount that needs to be adjusted could be granted. No, my lords, I am in respect of the RPFC, the revision petition that is concerned, the arrears as on today are about 1 crore 60 lakhs. My lords, I do not dispute that 16 lakhs has not been paid. It's been paid. Your lordships, in fact, passed an order in December. Your lordships could go through that order, wherein your lordships, in fact, had granted 2 weeks' time for him to pay a sum of rupees 11 lakhs. He does not pay. Then on Jan 9th, your lordship again passes another order. They give a check before this honorable court, wherein I in fact disputed, stating that I in fact resisted that, stating that those checks will not be encashed. Your lordship said no. Let us see whether it will be encashed. If it is encashed, it's good. Then your lordship passed another order in February stating that the checks were not encashed because the checks were not cleared. But subsequent to that, the subsequent events are such that after your lordships vacated the order, your lordship, there were 2 orders. One is 9/4/2024. The coordinate bench of this honorable court passed an order stating that granted a stay, stating that instead of 1 lakh, deposit a sum of rupees 50,000 every month towards at the rate 50,000 every month. Arrears can also be paid at the rate of 50,000. 3 months was granted for the said order. It was not complied. Then thereafter, your lordships passed another order because they made a submission that
she cannot claim maintenance both in an MC proceeding as well as the 125 proceedings. Therefore, your lordship said on 31/7/2025, your lordship said do not precipitate. Thereafter, your lordship met the man in the chambers, both the wife as well as the husband. Your lordships were very clear about as to what he is, because I had placed certain videos before your lordship stating that he has all the time to have a Bollywood birthday party, and he's living with another woman and he's taking care of that woman's child. Your lordship have seen those videos. Subsequent to that, your lordship said, okay, let his father come and meet. His father does not turn up. There is an order to that effect. Then your lordship said that, okay, let's hear this matter. Your lordship has granted several opportunities to him, and 62 lakhs is paid. I'm not denying it, your lordship, but my lords, but what happens here is now the arrears as on today is 1 crore 60 lakhs, because 9/4/2024 order, which was modified to 50,000, has been vacated because he did not comply the said order within a period of 3 months. Then your lordship's order of January as well as February has not been complied. Now he pays 16 lakhs, which is not even 10% of the arrears. Educational fee is not paid. She has a daughter. Educational fee would have to be paid. The order of the trial court, as far as I am aware, is until such time that she secures an employment. She's still studying. She's turned 18. There are about 5 years for her to complete her academics and secure a job. That being the case, then they produce a medical certificate before your lordships, which we have, in fact, we've stated that is not a medical certificate that's not a medical certificate at all, because it has no sealed signature of a doctor. On he has all the time to come on Feb 8th, sign get the affidavit notarized, and Feb 10th he goes and gets himself operated in Bombay. But he's been roaming scot-free without even taking care of. It's been 16 years since the proceedings have been initiated before the trial court, and not even until we got a warrant issued, only when he was arrested did the payment come. That is what my submission would be, my lords, because even as on today, they claim that he's not keeping well, he's undergone a heart surgery. Whatever said and done, it is his duty bound to take care of his wife and children. He has a time to live with his paramour, but he does not have the time to pay his wife and his own daughter, my lords. State of affairs is pretty bad.
I am not disputing. There are too many facts. But as the thing says, there are hospital stamped records showing his medical condition. One, but if he is going to get arrested, the check not honoring was because his father and son, I don't know, it was his father's checks, not even his checks. That's a problem. After that, instead of 10 lakhs, I paid 15 lakhs. I am not saying that I have been consistently following the orders.
But the outstanding is 1 crore and.
Well, that is because it becomes 1 crore, because the moment your lordship vacates the order, everything doubles. We'll see 1 lakh per month. And the moment your lordship vacates the order, 50,000 becomes 1 lakh. It becomes 1 crore 90 lakhs. So I'm saying, my lord, I will deposit at.
According to you, what is outstanding?
My lord, should be around about 35 lakhs, 36 lakhs. My lord, I've just been briefed. This is the amount. I've got some figures here. Here's 35 lakhs. The only other thing is, as far as the daughter is concerned, it's a technicality. She's attained majority.
There are judgments of the apex court.
I agree, but that will have to be decided on its own facts, not along with the mother's. And the trial court, my lord, has not taken into account some businesses he started which closed. Nothing has been taken into. And then the learned trial judge says, no, till she gets married, you pay. How much should be paid to her? Nothing is mentioned in the order. That's what I suggested in the beginning. Well, I'll make some payment. Let me see if I can sort out.
This is what is happening from, if you look at
2024
the order sheet.
No,
how many times the court has in fact.
That is why. That is why
default on the part of the petitioner.
I am not.
Petitioner is not.
I am not offering any excuses.
No,
I'm only saying.
Why should the court consider?
I'm only saying, my lord, if he goes behind bar, situation is only going to get worse. My lord, he's not going. As it is, he's not. He's been thrown out of the merchant navy. He was working there. Because of physical inability, he can't talk, he's tottering. I mean, there's no proper limb cord, he's been terminated. But if he goes into jail, it's going to further thing. I'm trying and solve.
Medical documents in support of that.
Yeah, I've got it. Last time they said that it was not sealed.
Where is it?
I've got it. Just now I got it.
Take that.
copy ಕೊಡಿ ಅವ್ರಿಗೆ. Wait till they give.
Regarding the margin,
Papers were given to them?
I'm due to know, right, because we got it sealed by the hospital and then.
But there's only one submission.
Originals are given to you.
If I could just draw my lord's attention to order dated 25/10/2024, which we had in fact on an earlier occasion we had placed the order of the Honorable Apex Court. He challenged that order in Apex Court. The Apex Court said nothing, you have to pay arrears. Order dated 25/10/2024. I had placed the Honorable Apex Court's order. They in fact come before the Honorable Court on 25th of October 2024, my lord, if I could just read this out. Learned counsel for the petitioner seeks time to secure instructions from the petitioner with regard to the payment of arrears of maintenance. This Honorable Court says that I am at liberty, there is no interim order, I am at liberty to execute the order. My lord, these are the bona fides, that is the reason. Now, they seek time and they challenge this very order before the Honorable Apex Court. What are the bona fides, my lords, that they have shown? Can we trust them?
There are no bona fides on the part of the petition. That he has exhibited it on so many.
Please place this on record. And let me in fact go through this order, my lords. This alone is sufficient, my lords, as per my understanding, to demonstrate as to what the conduct of the petitioner is.
Not when a man is physically not able to work, does 125 still cast an obligation on him in proprio vigore to say that he has to maintain to whatever extent has been ordered? He's not in a position, he can't talk, he's tottering.
My lords have met him in chambers. My lords have in fact.
Look at these documents once.
I'll give him a copy.
My lords may have it day after, if I may request, please.
This is matter day after tomorrow. Then counsel for the petition, let the senior counsel appearing for the petition submits that petitioner has suffered an attack. He is even not in a position to walk and talk.
My lords, that
That is a submission.
That is my submission.
That also depends on the lifestyle that is living, my lords, because of the videos that have in fact played before your lordships as to what lifestyle. My lords, I cannot, my lords, these are reasons after reasons that they're coming up. I'll anyways look into it and respond. I shall do that.
And they have filed the medical records before this court. Learn counsel for the respondent. The petition should serve the same on the counsel for the respondent. And list is matter day after tomorrow.
I request a lot to keep that arrest in abeyance at least.
I've already given him so many times that order.
No, that I don't dispute at all. But
day after tomorrow we'll see.
Pleasure.
Yes.
Cell number 55.
Lords, in this matter, I appear for the respondent number 2 authority.
For dismissal.
I appear for the respondent number 2 competent authority, my lords. My lords, the
To the
petitioner.
This is a petition of 2022. When this matter came up before this court on 1/4/2026, and there was no representation on behalf of the petitioner, the matter was directed to be listed on 2/4/2026. On 2/4/2026, this court has directed the matter to be listed on 6/4 under the same caption. Today also there is no representation. Accordingly, dismissed for non-prosecution.
Cell number 56.
To the petitioner, my lord. We filed NOC Okada today, my lord, so kindly grant us some time for reading the file, my lord.
I'll
Written
make
order may
one
kindly
submission,
extend.
my lord. They have not complied and not paid single 1 rupee, my lord.
My lord,
Kindly
just
see
got
the
the
order
case.
sheet, and they have no courtesy to serve the notice to the respondent through bank. Then I applied the copy. Then I obtained it. Your lordship, it is similar to earlier matter. He has challenged the final order passed by the DRT under section 17(1). There is an efficacy remedy available. As your lordship earlier passed this similar order. The efficacy remedy is available.
And moreover, your lordship kindly see my objection statement. They have not complied the order. That's what I make.
Lord, we just filed wakalat today, so please grant us some time.
And my lord, I served the copy, your lordship kindly see, it's a returned answer. Served the objection by way of, earlier some proxy counsel has been appeared, they refused to accept because his wife is admitted in hospital. On current sake, I have no objection. Your lordship kindly see last date of hearing. Thereafter, I sent by post, rejected return.
Serve him no.
Present advocate, I cannot.
Then counsel for the respondent has handed out the objections to the counsel for the petitioner.
Interim
Who has come on record.
Interim order may kindly be extended, my lord.
Interim order, no complaints, so what interim order may be?
Who is yet to come on record or have already come on record?
Today I came on a record, my lord.
Today, who has come on record on NOC? Then counsel for the respondent submits that the writ petition is not maintainable. Petition has an effective alternative remedy. He has relied on an order passed by this court in WP number 28199 of 2025, dated 16th February 2026. Then counsel for the petitioner seeks time, lists this matter on 16th of April. No further time.
Number 57.
It is submitted that the interim order is also not complied.
Not complied.
Yes.
And not served the notice also. Your lordship kindly see. In direction is there, not served. Then I applied certified copy and obtained.
57.
Appearing for the petition in this matter, my lords. May I request this court to kindly have the matter tomorrow matters. I have some inconvenience today. My wife is admitted in hospital. I'm in the hospital right now. It may be taken tomorrow, my lords. I'll appear personally and do the matter.
This matter under the same caption on 25th April.
Then number 58.
Tomorrow or day after tomorrow, my lords, if I may request kindly, my lords.
In this, I appear for petition. I'm
58
sorry, my
and
lord, on the
59.
last occasion, I was held up in the other court. By the time I come, my lord, it was posted for dismissal.
Yes, argue.
My lord, 58, 59, objection needs to be filed.
Huh?
Objection needs to be filed. 58
Objection
and
is prepared.
prepared, my lord, it will file, my lord. Within a
It is
week, then I'll
submitted by
file.
the learned AGA that the objections are ready in both 58 and 59.
Both.
And they'll be filing within 2 days. This is matter on 21st of April.
My lords, in serial number 57, in the interim order may kindly be extended.
I'm not extended on the last occasion, so we can't extend it.
It was occasional. It was extended, my lords. Kindly check it, my lords. It was extended, my lords.
Look at it. Dismissal matters, it will not be extended.
But
In the
actually, my lords, when the matter was actually called out, we appeared later, and this court was pleased to extend the interim order.
Look at it. If it is extended, it's extended. Yes, next 60.
Next matter is also same.
60.
The next matter, my lord, I appear for petitioner.
60.
No, my lord, 59, my lord.
Both
No, 58, 59, he said so.
Grateful.
In those matters, if interim order is there, extend 58 and 55.
Number
Yes, 60.
60, it has become infructuous. There was a show cause notice issued.
Hmm.
Subsequently, that we have passed an order. They are agreed by that they have to challenge that particular order.
Where is the petitioner counsel? The writ petition is of the year 2023. There was no representation on 1/4/2026, and the matter was directed to be listed on 2/4. On 2/4, this court has directed the matter to be listed on the same caption on 6/4. Today also, when the matter came up, there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to pursue the matter. Dismiss for non-prosecution. Accordingly, dismiss for non-prosecution. 61.
Kavita D.
And for the petitioner, I'm challenging the section 14 order in this. Petition may be dismissed with the liberty to approach the.
I'll not, in this matter, as there is no stay, I will not say that you have the, and have you
Was a
complied
stay.
with the interim order?
There was a stay, my lord.
Have you complied with the interim order?
Yes, we have complied the interim.
When did you pay?
We have paid. We have missed out the file, my lord.
Huh?
We have missed out the file in the office. That's the reason.
I'll take up this matter tomorrow. Please tell the court when is the interim order complied with.
Yes.
If the interim order is complied with, I'll give you the protection of section 14 or else no. Take this matter tomorrow under the same caption. The land counsel for the petition shall get specific instruction whether the interim order is complied with or not. Yes, in the first list, call the passwords.
First list passover matter. Sale number 19. Naveed Ahmed.
For the respondent. The sale notice has been challenged.
There is a counsel for the petitioner. Yes,
As for the petitioner, my lords.
yes.
Lords, in compliance of the lords interim order, lords, we have deposited, my lords, sum of rupees 20 lakhs. Lords,
Is
now,
it a nationalized bank?
lords,
Is it a
nationalized
nationalized?
bank, lords.
Come to the prayer.
Lords, now, my lords, they have also opposed the DRT, claiming, my lords, kindly see, my lord, the application I have produced, kindly see page number 55, my lords.
No, what is the prayer in this writ petition?
Lords, for setting aside, my lord, the action notice, sale notice, my lords.
What happened to the sale notice?
That is stated by this court.
Sale has not conducted.
No, not conducted.
Then we'll dispose
Yes,
it
sir.
of. The
And my lords,
Writ petition has become
kindly,
instruction.
let's kindly, see, lords. Lord, they have approached the DRT that I have produced before this court. Please kindly see page number 55. Lord, they are seeking direction before the DRT, directing not the petitioner here to deposit the entire loan amount. That is not pending. In the meantime, lords, kindly see the interim order of this court. Lord, we have deposited 20 lakhs and that is kept in a lien account, subject to the outcome of this petition. Lord, I have no objection, lords, let the petition be disposed of, relegating the parties to the DRT. Lords, the amount that is in deposit, lord, that should be released in my favor, lords.
No, the amount was ordered to be deposited in loan lien account.
Lord, that is subject to the outcome of this petition that is in deposit, lords. Subject to the outcome of this.
What is the purpose of keeping this writ petition pending? What is the purpose of paying the amount or depositing the amount?
Then I will argue on merits, my lord.
No,
If it is,
sale notice,
lords,
you-
if it is,
It is like this, you have questioned the sale come auction notice.
yes,
Auction notice, auction is not conducted.
not conducted.
Then what will you argue on the merits of the matter?
Lords, they are before the DRT. Lords, I am not.
You have got
Lords,
the
one-
sale deferred
Lords,
by paying the amount.
Lords, I have got lords instruction to say that lords, we have offered them lords about 80 lakhs. Lord, that is the lords, the difference is only lords 85. They are claiming 90 lakhs, lords. 10 lakhs is the difference, lord. If the matter is referred to mediation, lords, we will pay and settle it. Not an issue.
Now, as far as the interim order is, because of that interim order, you have been enjoying the stay from the last 2 years.
2 years.
Yes, I am ready to
Not
pay.
say, I will not
Lords,
say you return the amount.
Lords, I am ready to pay even.
Whatever is the amount, let it go to the bank. Whatever is the remaining amount you want to pay.
Lords,
pay it
if
to
it is disposed of, lords, again the litigation will go on.
What do you want the court to decide?
Let it be effort to lords, the mediation, lords. We will close this matter, lords. I am ready to pay. I am ready to pay, my lords.
Seeking the following prayer. The land counsel for the petition submits that the petition is ready to settle the amount and the matter may be referred to the mediation center. Land counsel for the respondent bank, what is?
Your Lordship, the challenge is in respect of the sale notice.
Land counsel for the respondent submits that.
They are enjoying the
petition has
interim
questioned
order
the
since
system
2 years.
Money, sir. You
And
will
right
get
from
your money.
2024, they are enjoying the interim order. And it is submitted that the petitioner,
Has not,
nothing is authorized for consideration in this writ petition. Land counsel for the petitioner submits that by way of an interim order, an amount of rupees 20 lakhs is paid. The same may be returned to the petitioner.
Your Lordship, the amount in deposit may be
The amount in deposit may be returned to the petitioner.
to the loan account, since he has
That
enjoyed
is
the.
his submission,
Yes.
the amount in deposit may be returned to the petitioner. Land counsel, in response to that, land counsel for the respondent submits that the petitioner on depositing the said amount is enjoying the interim order from 2026. And now that amount cannot be returned to the petitioner, but it should be adjusted towards, should be given to the bank to adjust towards the loan amount. Next paragraph. The relief that is sought in this writ petition is questioning the auction notice. the essay is pending before the DRT. There is no dispute about the fact that there is an outstanding amount. According to the petitioner, he wants to settle the amount. As far as this writ petition is concerned, the sale notice that is issued, as per the sale notice, the auction was not conducted, and this writ petition on that aspect has become infructuous. There is nothing to be decided on the merits of the matter. Coming to the return of the amount is concerned, this court cannot return the amount to the petitioner. Petitioner is enjoying the interim order from 2024 till 2026. In that view of the matter, the amount that is deposited shall be given, the bank is at liberty to withdraw, and there shall be a portion to the loan account. Accordingly, this court is passing the following order. The writ petition is dismissed as infructuous, and if the petition is agreed by any other action, he is at liberty to avail the appropriate remedy before the DRT. Number two, the amount in deposit shall be, the bank is at liberty to withdraw and apportion the same to the loan account.
So number 20.
Lords, I'm ready to settle it, Lords. I'm ready to pay.
Go to them.
They will not entertain, Lords. If there is a direction, Lord, they will entertain, Lords.
What is the direction you want?
Lords, let them, Lords, entertain my application, Lords. Even I'm ready for
Can there
voting.
be a direction of that nature?
Lords, I will give a presentation. Lords. Let them consider, Lords. Lords, I'm ready to pay, Lords.
It is submitted by the last three. It is submitted by the petitioner that he is ready for a settlement. If that is so, the petitioner is at liberty to give a representation to the respondents, and the respondents are considered the same in accordance with.
Public.
Yes, next.
Yeah,
Number?
20. I may be permitted to.
No, what is the number? What you have called is 20.
Fellowship, I may permit it.
My lords, I am for the petitioner in this case, my lords.
What is that?
Objection.
Objections
Have
there.
you given him?
Yes.
You are ready to argue?
Yes, my lords.
Yes.
My lords, in this, my lords, prayer may be looked into, my lords. Page number 35.
Come to your prayer.
Yes, madam. Page number 35. Lords. Page number 35, my lords, to quash.
Willful defaulter.
Yes, to quash the notice for the declaration of willful defaulter dated 6/6/2024 issued by respondent number 3. To quash annexure B forensic audit dated so and so issued by email by respondent number 2 and 3. My lords, I'll be limiting my arguments only to these two prayers, my lords. My lords, page number 40 may be looked into, my lords. Page number 40.
Yes.
Yes, my lords, this is the willful defaulter notice given by the respondent bank on 6/6/2024, my lords. My lords, page number 42 may be looked into. My lords, they have.
This is dated?
6/6/2024.
A notice is issued to you.
Yes, this is willful defaulter notice, my lords. My lords, 6/6/2024 willful defaulter notice has been issued. My lords, 6/4/2024, they issue a show cause notice. My lords, that notice is along with the application which I have filed on 12/2/2026 with an application. Page number 14 of that application may be looked into.
No, I didn't get you what you submitted.
That's 6/6/2024.
No, this, you are referring to 6/4/2024 notice.
No, my lords, this is 6/6/2024. Annexure A is 6/6/2024.
42 page number, what is it?
Yes, my lords, page number 42.
It is
My
a
lords,
notice
in
given
that,
to you.
my lords, in that, they have mentioned.
Show cause notice
Yes.
dated 6/4/2024.
24. That letter I have annexed along with an application that is filed on 12/2/2026.
Where is it?
Page number 21, my lords, of that application.
Where is that application? Page number?
21, my lords.
Yes.
My lords, is that 21?
Yes.
My lords, this is 6/4/2024. This is show cause notice. My lords, kindly turn the page to page number 22, my lords. My lords, this show cause notice is issued and signed by chief manager. My lords, there are 3 or 4 show cause notices to different companies.
Yes.
My lords, now, my lords, page number 41 of the same IA may be looked into. 41. My lords, this is the RBI circular in which there is a mechanism for the respondent bank who has to issue the notice. There has to, yes, my lords. My lords, clause number 3, mechanism for identification of willful defaulters. The mechanism referred in so and so above generally include the following: the evidence of willful default on the part of borrowing company, its promoter, whole-time director at the relevant time should be examined by committee headed by executive director or equivalent and consisting of 2 senior officers of the rank of GM and DGM. If the committee concludes that an event of willful has occurred, it shall issue a show cause notice to the concerned borrower and the promoter so and so and call for their submissions, and after considering their submissions, issue an order recording the fact of willful default and the reasons for the same. An opportunity should be given to the borrower and the promoter / whole-time director for personal hearing if the committee feels such an opportunity is necessary. My lords, in this case, my lords, this clause of RBI circular has not at all been complied with respondent bank.
Yes.
That is one.
Yes.
My lords, I'm not yet finished, my lords. I'll point out the objections filed by my learned counsel, my lords. Page number 140 of that objections may be looked into, my lords. My lords, after the show cause notice was given, the petitioners have issued a reply notice and that has not been answered by the respondent bank. My lords, page number 140.
Yes.
My lords, serial number 2, 3, 4 and 5 are the petitioners. And the last column, my lords, I may read. At the time of slippage, there was no willful element found in the conduct of accounts. During the process of recovery, stocks were disposed of without the knowledge of the bank. Hence, willful default angle was examined and declared willful defaulter. That is one. And my lords, page number 46 may be looked into. 146. This is one of the petitioner in which the fraud status column says that no fraud. And the other petitioner, that is petitioner number 2, the fraud column status say that no fraud. My lords, page number 150. Again, there is no fraud column in this. My lords, there is no fraud column for Shashank Cashew Industries, one of the petitioners in this case. My lords, page number 142. One of the petitioners, again, no fraud reported. 152, my lords. My lords, my only contention before this honorable court is the RBI circular, which they themselves.
Understood, that's why we'll ask
Yes.
him. Yes.
Yes. Your Lordship, now the Supreme Court of India in.
What is the procedure to be
Yeah,
followed for declaring the
yes,
person entity as a willful defaulter?
Yes.
He has already filed the guidelines.
Yes, guidelines. Sir. Your Lordship, in the case of State Bank of India versus JA developers and others, the Supreme Court has held how the RBI banks has to deal with the willful defaulter. Page number 4, Your Lordship. May take 4. Para number 4.
Yes.
Yes. On 1/7/2015, the RBI issued another master circular consolidating the instructions how the scheduled commercial banks and notified financial institutions are to deal with the willful defaulters. The
Just two years read it.
Yes, yes.
The same thing.
Yes. Yes. Now,
I'll
substantiate.
I will only point out one second. Yeah. In the same judgment, kindly take out page number 25. I was about to give this judgment. Page number 25. Page number 25, my lords.
There is no page number 25 to this judgment.
It's at the
I
bottom.
have a copy. I can
Oh,
read
yes,
out
25, 25.
At the bottom. of-
25, my lords. My lords, in this, I'll read out, my lords. This being so, given the fact that para number 3 of Master Circular dated so and so permitted the borrower to make representation within 15 days of the preliminary decision of the first committee, we are of the view that first and foremost, the committee comprising of executive director and two other officials, being the first committee after so and so must give its order to the borrower as soon as it is made. The borrower can then represent against such order within period of 15 days to the review committee. Well, this judgment is not at all complied with as well. The RBI circular is very clear that the chief manager.
Yes.
Yes.
Why are you relying on this judgment?
Now, the mode in which the bank has to deal with the declaring the.
No, the Supreme Court did not say because your circular.
Yes, yes. Now, your lordship, now may I submit your lordship the.
Because the committee now, as per bare perusal of these, the master circular.
Yes.
First, you should appoint a committee.
Yes.
That committee would look into whether there is.
Now may I submit
He
your-
can be declared as a willful defaulter.
Yes.
Then once they feel that he can be, then a notice will be issued.
Yes.
After that, he will appear before the committee.
Yes.
Then his evidence would be considered. Then there in the next eventuality should be committee referred to the other committee.
Yes.
So
Review
in
committee.
this case,
Yes. In this case, your lordship, the bank has gone through the default committed by the bank petitioner.
Where is the committee's
Yes,
proceedings?
first your lordship, page number 14, R1,
Page number
14,
14.
14.
Ah.
It is the identification of the,
This is 12/3/2024.
yes,
Hmm.
the committee felt, they have formed a committee and committee felt these petitioners have committed default
No, my
and
lords.
ordered for issue of.
Where do you get that?
Page
Your
number
lordship,
15, no fraud reported. The same.
May I take your lordship?
Next page.
Identification,
Let him
page number
complete,
14.
after that you can respond.
Page number 14. Identification of willful default and permission to issue of show cause notices to the borrower from Messrs. Shashank Industries and other partners. There are 4 other cases. In page number 18, your lordship, the notice was ordered.
Oh, no, what did this committee do?
Initial show cause notice. Your
No,
lordship.
no, it's talks about the profile of the company.
Yes,
Nature of bank.
yes.
limit
And
sanction,
circle
then
recommendation. they have
Background of the
recommended.
account.
Yes.
Security
16,
details,
page number 16, your lordship.
circular recommendations.
Yes.
Then page 16.
16, your lordship,
Sir, willful
the unit
default.
has defaulted in making the payment and repayment of the obligation to the lender and has disposed or removed mobile fixed assets of immobile property given for the purpose of securing the term loan without the knowledge of the lender bank. Defaulted in meeting the payment and repayment obligation to the lender and has not utilized the finance from the lender for specific purpose for which the finance was availed, but diverted the funds for the other purpose. So now the recommended, following the responsible acts, omissions on the day-to-day affairs of the borrower firm, hence liable to be classified the willful defaulter. In view of the above, we recommended to permit, your lordship, to permit the circle branch to 15 days show cause notice to the above persons. In case any representation is not received within 15 days, we may be permitted to classify the borrower partners guarantees as willful defaulters once the decision of identified committee is confirmed by the remit committee for the defaulter. This is the page number 18, your lordship.
Then you have pursuant to this.
Yes.
You have issued a notice on
Yes.
6/4/2024.
Yes.
Now let's come to that notice of 6/4/2024
Yes.
642.
that he has filed along with the, or you have filed.
Application.
Application.
6/4/2024 show cause notice.
Yes. 6/4, your lordship.
Page,
That's 86 of objections. 86.
what is that? 30?
86 of the objections. 86.
Yes, we have issued the notice 6/4/2024 to all the borrowers and required them to submit their reply. They have, we have sent the notice by.
No, where did you refer to the committee? In view of the above, you are coming within the purview of the willful default as defined the RBI. Hence, the committee proposes to classify you as a
Yes.
willful defaulter
Yes.
and report.
Following
the
reasons.
Information companies. in
So
this
the
regard,
notice
same
was sent to
furnished
the,
the company?
yes,
Yes.
notice was sent to the parties. They have
Now,
not.
what is wrong with this?
My lords, the
He has not replied.
RBI circular, my lords, page number 41 of my IA, my lords.
Hmm.
My lords, in this case, the chief manager has issued the show cause notice.
Committee has given, that is the first, the master circular doesn't say that the committee will issue the show cause notice.
My lords, they have to give, my lords, the table of committee, who are the identification committee, who held the committee, I mean, who held the meeting, my lords. As per this, my lords, if the committee concludes that an event of willful default has considered, it shall issue a show cause notice. My lords, this doesn't say that the chief manager has to issue a show cause notice. This clause itself is clear, my lords. If
Come
this,
to, just now he has read the recommendation. Please come to that. It is very clear. Come to the recommendation. Where is that page number? 12/3/2024 recommendation. Where is it?
yes, to
14.
permit,
Come to 14, page 14 of his.
page number 17, my lords. 17.
Please come to that. Now, to permit circle oblique branch
Yes.
to issue 15-day show cause notice.
Yes, my lords.
It will be issued by the concerned bank, but not by the committee.
My lords, but the RBI circular
RBI
is very
circular
clear.
need not say that. RBI circular is very much clear. Please read the RBI circular.
Yes.
There is
Page
no
number-
ambiguity in the circular at all.
Page number 41.
Yes, please read. Nowhere it says that the committee will give the notice. Yes,
My lords, the second,
read A.
the evidence of willful default on the part of borrowing company, its promoter, whole-time director at the relevant time should be examined by a committee headed by executive director or equivalent and consisting of 2 other senior officers of the rank GM and DGM. My lords, if the committee concludes that an event of willful default has occurred, it shall issue a show cause notice to the concerned borrower and promoter / whole-time director and call for their submissions after considering.
Paragraph number 2.5.
My lords,
Come to paragraph number 2.5. Because committee will not issue the show cause notice.
my lords, I am relying on a judgment, my lords, of the
2.5, let us read.
2.5 of the RBI circular, my lords.
Yes.
The following measures should be initiated by the banks and FIRs against the willful defaulter identified as per definition indicated and so and so. No additional facility should be granted by any bank / FI to the listed willful defaulters. In addition, such companies where banks have identified diversion of funds, misrepresentation, fraudulent transactions should be debarred from institutional finance from the scheduled commercial banks, financial institutions, NBFCs for floating new ventures for a period of 5 years from the date of removal of their name from the list of.
What is the prejudice that is caused to you that you can tell the court?
My lords, there is a RBI circular.
No.
My lords,
That apart, what is it? No, they didn't do anything.
My lords,
As
they
per
have
the
issued.
committee recommendation, they have issued a show cause notice. You have to go on represent, give your reply representation.
Yes.
Your evidence will be considered by the committee.
Correct.
What is the prejudice in that?
Yes,
I'm
my
not
lords.
able to
My lords,
understand.
they have issued the show cause notice on 6/4/2024. My lords, I have replied to that.
No, you are
On-
going back to that. First of all, clarify the first aspect. And a show cause notice issued by the chief manager, but not the committee. What is the prejudice caused to?
My lords, the show cause if the show cause notice itself,
It is pursuant to the recommendation of the committee. The chief manager is only a kind of an act in pursuance to that.
my lords,
There
I'll-
cannot be any prejudice to you because he has not taken an independent decision.
My
If the
lords-
committee is not constituted, chief manager has issued a notice to you, then it's a different aspect.
yes, my lords,
No,
but
just it's more or less on a technicality.
yes, my lords,
They have to
but
look at the master circular and also what is the prejudice caused to you.
my lords, their document itself at page number 140,
For
I read, my
that-
lords,
For that
they-
comes the next step.
they themselves have mentioned in that page number 140 that there is no willful
Okay,
default.
that is on the merits of the matter.
Yes.
That's on the merits of the matter.
Yes.
No, as far as your first submission is concerned, this court is of the view that no prejudice is caused to you
My lords,
by
the
issuing a notice
prejudice-
by the chief manager.
My lords,
So
the
your
pre-
submission I have recorded.
Yes.
I understood
Yes.
that according to you, as per this circular, he has to issue. You do not deny the fact that a committee is constituted and the committee has passed an order.
Yes, ma'am.
So that is now number one, your submission that we will deal with. Next, number two.
My lords, can I pass on this judgment?
No, we look at the judgment. Number
Let's-
two.
Number two, my lords, my only submission is based on the show cause notice, willful default notice, that is 6/6/2024. My lords, the threshold show cause notice itself is contrary to RBI circular. If that is the case, my lords, they could not have sent the willful defaulter notice that is on 6/6/2024. After which also they have given a forensic audit notice dated 3/12/2025. My lords, based on these three notices,
Go step by step. They have issued the show cause notice. You have submitted your explanation or you have given him evidence before the
reply.
committee.
No reply was given.
Then after that, the evidence part will come.
My lords, yes, my lords, if the show cause notice has been contrary to the RBI, if the reply has been given, my reply was given on 22/5/2024. That has not been considered as well, my lords.
Will consider.
My lords, the committee, the identification committee or the review committee, my lords, SBI versus JAR developers, they,
Don't go to the judgment. Look, come to this.
My
Come
lords,
to
the
the
re-
master circular.
my lords, the master circular is very clear that the show cause notice has to be issued by committee.
That's what you said. I understood. Next, what is to be done after that? From the circular, you tell the court. You shall issue a show cause notice to the concerned borrower and the promoter, whole-time director, and
Yes.
call for their submission. So your submissions are made.
Yes.
You have
my
given
lords,
the submission.
the
And
next,
after considering their submissions, issue an order recording the fact of willful default and the reasons for the same.
Correct.
Where is that order? Where is that order?
my lords, they have to produce that, my lords. There is no such order according to us.
So only you are before the court on the technical aspect.
Yes, my lords, because my lords, it is only the bank has issued the notice and they have mentioned that RBI circular in the show cause notice. That show cause notice itself is contrary to the,
No, that I will answer. That I
Yes.
will answer. Next.
yes, my lords,
Give the judgment also.
yes. One minute.
Yes.
My lords, the first one was SPA versus JAR developers. My lords, my learned friend already pointed out.
Pronit's case, which paragraph?
My lords, page number 29.
No, Pronit's case is only till page 11.
Lords, no, I'm not relying on Pronit's case. Pronit's
Then?
case is only with regard to other prayers.
Ah.
Page number 29 is State Bank of India versus JAR developers, Apex Court judgment.
Page number 29.
Yes, please, 29.
What is this judgment?
Well, it's the same judgment which my learned friend relied upon. State Bank of India versus JAR
Can
developers.
you file this legal?
Yes, yes, my lords.
Web.com.
My lords,
Ah.
my lords, in this
So did
case,
they say that it should be given by the show cause notice should be
yes,
given?
my lords. I'll read out, my lord. I'll
Yes.
read out. This for the reason, my lords,
Where are you reading?
my lords, from third line, my lords.
Which page?
Page number 29.
Mm.
Plus, this for the reason that no additional facilities can be granted by so and so, so and so. Malas, I'll read out from,
Yes, yes.
yes, Malas, I'll read out from given these drastic consequences. Malas. Given these drastic consequences, it is clear that revised circular being in public interest must be construed reasonably. This being so, and given the fact that para number 3 of master circular dated so and so permitted the borrower to make a representation within 15 days of preliminary decision of the first committee. We are of the view that first and foremost, the committee comprising of executive director and 2 other senior officials, being the first committee after following so and so, must give its order to the borrower. Malas, this has not been done so.
What is not been done?
Malas, para number 3, paragraph 3B of revised circular dated so and so must give its order. Malas, this refers to show cause notice. My lords. The committee itself has to give the show cause notice, but in this, chief manager has been.
Yes.
My lords, the borrower can represent against such order within a period of 15 days to the review committee. My lords, I have done so. I have already replied on 22/5/2024.
You are awaiting for that, so that's
Yes.
not the.
Yes, such representation, such written representation, be a full representation on so and so. The review committee must then pass a reasoned order on such representation, which must be served on so and so. My lords, which must be served on the borrower. The review committee has to
No, you have not
consider
gone
my
to that
reply.
stage. You have not gone to that stage. You are saying it much before.
Yes, my lords, but even after which also.
Let's not.
Even
go
after
to,
which also.
Let's not go to those assumptions.
Well,
You
that's
are on
even
the point. You restricted to that point. We will pass orders on that.
Yes, yes.
No, nothing has happened after that. You are only agreed with the notice is given by the
Show
chief
cause.
general manager, but
Yes.
should not be by the, should be by the committee.
Correct.
And you have represented. That
Yes.
is pending consideration.
Yes, yes.
But you are questioning it because it is given by somebody else without even urging what is the, what it is not your, what is the, prejudice that is caused to you. No prejudice to you.
My lords, if
For the sake of it, you have come to the
my
court.
lords, the prejudice is, if the show cause notice is contrary to the RBI, they actually publish that show cause notice in vernacular language in all the papers, in English and Kannada.
So
If that
no, if
notice
that
itself is,
that is printed,
if
is
that
published-
notice itself is contrary to RBI, my lords,
No, no,
if
if that
the
is
public
published,
image is,
if that is given by the manager, then you are not aggrieved by the committee. If it is printed
lords,
in the
if that
vernacular
would-
language, nothing will happen to you.
my lords, if that would have been the case, I would have replied, my lords. In that reply
You
also,
have
my lords,
replied even now. You have
Well-
replied.
my lords, even now, my lords, let them withdraw those notices.
No, no, no.
My lords, I'm
No.
convincing this honorable court on the show cause notice, my lords. I have already produced one more judgment, my lords, the writ petition number
On that
685.
point, I'm not convinced.
My lords,
Not-
page number 30 may be looked into. In
Which-
this
which
case,
30? There are so many 30s
my lords,
here.
citation memo, my lords, citation memo.
Yes.
Page number 30, in this case, my lords, same aspect has been considered by coordinate bench, my lords. I have,
30 is some
685.
RPAD.
my lords, citation memo, my lords, citation which I have.
Yes. Yes.
My lords, page number 30, in this case, my lords, I had challenged the same notice and my lords, page number 43, my lords.
Yes. Yes.
The show cause notice carries with it three instances. First, reasons for a default is that the borrower has defrauded the bank by mortgaging already sold property, my lords, in the different circumstances. Second, if the petitioner would not submit the reply, he would declare willful defaulter. And third, this committee has this has the committee approval. Barring this, there is no indication of any disclosure of reasons as to why the petitioner should be declared as willful defaulter. The notice is vague as vagueness could be. The guidelines are quoted supra, my lords. The RBI circular was quoted before, my lords. The guidelines of RBI have a statutory force. Is that what the apex court has held in aforequoted judgment in that, my lords, RBI, SBI versus JAR developers was relied upon. Therefore, it is necessary to consider whether the notice meets the necessities as enumerated under the guidelines. My lords, in this case also, my lords, page number 44 of the same judgment, there was no whole-time director, there was no chief executive director.
How
My
are you
lords,
concerned with all that?
My lords, if
You're
the
just jumbling the facts and law.
my lords, if the show cause notice itself is contrary to the RBI circular,
That I
they
understood.
could not have gone to the next step
That I've
itself.
understood your submission on that.
My lords,
No,
the judgment
other
is
things,
only,
all the judgments, whatever is discussed will not apply to you.
my lords, the judgment is only with regard to that. Show cause notice should be issued by the committee.
That I will record. Yes, please come. The present declaration is filed seeking the following prayers. Let counsel for the petitioner has restricted the arguments to prayer number A and B. That is to quash the notice for the declaration of willful defaulter dated 6/6/2024.
My lords,
Issued
before
by
that, my lords. My lords, page number 140, they themselves have stated that there is no willful default.
By respondent number 3. B, to quash annexure B, forensic audit notice dated 3/12/2025, issued by email by the respondent number 2 and 3. The facts of the case are: petition is the borrower. The petitioner is aggrieved with the notice dated 6/6/2024, and also the forensic audit audit initiated by email dated 3/12/2025. It is the contention of the petitioner that the petitioner cannot, the pleadings are running into 30 pages, sir.
My lords,
Not 30, 35 pages.
I'm
Prayers
just-
running into
My lords, I'm just arguing counsel, my lords, the.
3 pages, sir.
My lords, can I?
It is submit the learned counsel for the petitioner relying on the master circular issued by the Reserve Bank of India. Reserve Bank of India dated, where is the master circular?
My lords, page number 41 of my email. Dated 1/7/2015.
Is it in this blue compilation?
My lords, IA compilation, my lords, 12/2/2026.
Relying on the master circular. Is that page number?
My lords, 1/7/2015, my lords.
Dated July 1st, 2015. Submits that,
I'm relying on page number 41.
submits that the bank has failed to follow the circular, the master circular issued by the RBI. He relied on the paragraph 3, that is the mechanism for identification of willful defaulters. Basing on this, it is submitted that as per the circular 3A, the evidence of willful default on the part of the borrowing company and its promoter, whole-time director, should be examined by a committee headed by an executive director or equivalent and consisting of 2 other senior officers of the rank of GM/DGM. And as per B, if the committee concludes that there is an willful default, it shall issue a show cause notice to the concerned borrower and the promoter and call for their submission. Then an opportunity of the personal hearing shall be given. If there is a review as per 3C by another committee. The submission of the learned counsel is that one, the petitioner cannot be declared as a willful defaulter. Number 2, the committee who has examined whether the petitioner has committed willful default or not, should issue a show cause notice. According to the number 3, it is submitted that the show cause notice is issued by the Chief General Manager of Canara Bank.
Yes.
Canara Bank, which is contrary to the Master Circular, particularly Clause 3AB of the Master Circular. Further, it is submitted that there is in none of their reports, there is no default, there is no fraud on behalf of the petitioner. Even on those circumstances, there cannot be, the petitioner cannot be declared as a willful defaulter. In support of his case, he relied on 2 judgments. One is the judgment, an order passed by a coordinate bench of this court in Writ petition number 6850 of 2025. That is, in case of BC Chandrasekhar versus the authorized officer Canara Bank. And he relied on paragraph number?
Let's page number 40.
RBI directs at which one?
Yes, my lord. Page number 40, the RBI directs.
That I have marked that. From there to?
Let's still page number. Let's para number. There is no para.
11 also you're
yes,
relying
page
on?
number 45, my lord. Still.
11 and?
Let's, the opinion is.
43.
Yes, my lord.
Then
the opinion
paragraph
is.
Number 12.
And 40, till page number 45, my lord.
These are all the contentions. Then council seeks to submit the paying fraud is 13,
Yes,
14, till 15, till the end of the order, you write, you extract.
My lord,
He
the
has
opinion
also-
starts from 12. My lord. The
Entire
yes,
order.
12,
Entire
12.
order.
My lord, para number 12, the opinion of the coordinate bench starts.
Right from paragraph number 12.
Yes.
12 to the end of the order. He has also relied on another judgment of the Honorable Apex Court in case of, where is that? In case of State Bank of India versus Jar Developers. Jar Developers Private Limited and others reported in 2019, 6 SCC 787. Which paragraph? Yours is SCC.
Yes. No, I
No,
report judgment.
Where is that? He relied on paragraph number
4.
Paragraph number 21, then 21 and the entire 21. Relying on these judgments, land counsel appearing for the petitioner submits that issuance of the no-show cause notice by the chief general manager is bad and the same is liable to be set aside. And the consequentially also the forensic audit notice that is issued by the respondent bank needs to be set aside. And the respondent bank may be directed to follow the master circular issued by the RBI dated 1st July 2015. 1st July 2015. Next para. Learned counsel appearing for the respondent bank has filed the objections. He has drawn the attention of the court to the committee report dated 12/3/2024. The committee consists of
Page number 18.
the divisional manager, the general manager, deputy general manager, general manager recovery legal and FP wing, general manager mid corporate credit wing. As per this,
May I intervene, Malaj? Only one. This committee report is only with regard to Messrs. Shashank Cashew Industries. Only one.
There are 4 other. R2, 3,
This
4.
committee report, alleged committee report only is with regard to one of the petitioner, that is Messrs. Shashank Industries.
Where is others?
Others,
This is in page number 30, Your Lordship.
Page number?
30. R2, R3,
Yes.
R4.
The report stated 12/3/2024 and submits that the committee has considered the reasons for willful default, wherein in respect of Mr. Shashank Cashew Industries, it is observed that the unit has defaulted in meeting its repayment obligations to the lender, and also disposed of or removed the movable fixed assets or removable property given for the purpose of securing a term loan without the knowledge of the bank lender. Next, number 2, defaulted in meeting its repayment obligations to the lender and has not utilized the finance from the lender for the specific purpose for which finance was availed, but has diverted the funds for other purposes. Then when it comes to column number 5, with regard to the recommendations, in view of paragraph number 4, for the reasons of willful default, the recommendation was made. And it is the same, it also contains that in view of the above, we recommend, within inverted commas, in view of the above, we recommend as under to permit circle/branch to issue 15-day show cause notice to all the above persons/entities. In case any representation is not received within the reasonable period of 15 days, we may be permitted to classify the borrower and its partners/guarantors as willful defaulters once a decision of the identification committee is confirmed by the review committee for willful defaulters. 3, in case any representation is received, the same will be placed before the committee for identification and classification of willful defaulters for taking decision with regard to providing an opportunity of personal hearing if deemed fit. Then when it comes to, next, where is the next one?
Next one is at
Page number 30. When it comes to Messrs. SLV Ejamana Industries, also at column number 4, the same reasons as in the earlier case were recorded, and also the very same recommendations were made.
42.
And next is
42. Number
40.
2.
So almost recommendations are the same in all.
Yes, sir, yes.
In respect of all the.
My lords, in so far as my lords, the respondent 1 and 4 is considered, my lords, the prayer F does not make applicable.
No, he's not. He's only asking for 1 and 2.
My lords, in so far as prayer number F, it's not been pressed, my lords. Then
Nothing is pressed. He's not pressing anything.
That may be just recorded, my lords. So far as the union and the SME.
What did you write? Oh, record. It is submitted that the committee, as per the guidelines issued by the Master, as per the Master Circular by the Reserve Bank of India, they have constituted the committee, and a committee is constituted, and as per the committee's recommendations, show cause notice was issued to the petitioner. It is submitted that they have, in consonance with the guidelines issued by the Reserve Bank of India, they have issued the show cause notice, and the petitioner could not make out any legal ground. Learned counsel appearing on behalf of the DSG.
R1, no, my lords. Swamini Ganesh Mohan, CGC, my lords. Central Government Council.
It is Central Government Council appearing on behalf of
R1 and 4.
R1 and 4. submits that petition has questioned the validity of the circular.
No, my lords.
Ah.
He's seeking a direction to initiate an action on, as a result that the respondent bank has not complied with the RBI guidelines. So far as the initiating, my lords, that is the Reserve Bank of India has the power, my lords, in case if it is.
To initiate the action against the bank which has failed to follow the master circular. And it is submitted that the Reserve Bank of India has alone got the power to deal with the same. As the petitioner is not pressing any other prayer except 1 and 2, this court need not go into that aspect.
And 4 minutes. 1 and 4 minutes.
He's not pressing, he's only pressing 1 and 2.
Please.
Yeah, except the prayer 1 and 2.
Prayer A and B.
Prayer A and B, as he is not pressing the other prayers, this court need not go into those issues. The Reserve Bank, having heard the counsels on either side, there is a material on record. The whole grievance of the petitioner is that, as per the master circular dated 1st July 2015, particularly as per clause 3A and B, the show cause notice has to be issued by the committee. But in this case, the show cause notice is issued by the Chief General Manager. As such, that is contrary to the guidelines and the same needs to be set aside. The petitioner has relied on the judgments, there's an order passed by the apex court and the order passed by a learned single, the coordinate bench of this court. This court has specifically asked the petitioner, what is the prejudice that is caused to you if the Chief General Manager has issued a notice, has issued the show cause notice, except stating that it is contrary to the master circular. Petitioner has not submitted anything with regard to that, and he relies on the 2 judgments, one of the apex court and another of this court, that another judgment of this court, that the master circular has to be followed. As per the master circular, a committee has to be constituted.
With regard to prejudice, my lords, I had submitted before this court that the prejudice caused to the petitioner only when the publication was made, and this show cause notice.
If the committee gives a show cause notice, it will not be published.
My lords, if the show cause notice itself is contrary, my
No,
lord.
I'm asking if the same notice is issued by the committee, then it will not
My
be
lords,
published.
that is my lords, in this case, that has not happened, my lords. In this case, the show cause notice is issued by Chief Manager. The prejudice
I'm
only the prejudice
is-
caused by me, my lords.
It is not prejudice, sir. What you are submitting is, it's a procedural lacuna according to
Yes,
you.
and also
It
the
can't be
same.
No.
Yes.
Publishing in the paper can't be a prejudice because either a show cause notice by the Chief Manager or by the committee, both will be published in vernacular language.
Yes,
That
ma'am.
also, when the court has asked the petitioner what is the prejudice that is caused to him, it is submitted that you didn't write, what is the prejudice caused to the petitioner, it is submitted that if it is published in the way, when the show cause notice is bad, and if the same is published in the vernacular language, it would, what would happen?
My lords, it is already published. Because of that, I have been, my lords, the petitioners are under prejudice. These 2 are already published.
Oh, no. Anyhow, that will be published.
My lords, these 2 are published in the year 2024.
That I understand.
Yes, my lords.
That's what I'm asking you.
Yes.
If it is by the committee, if it is published in the vernacular language, then there is no defamation to the petitioner, but it's only by the manager. That has to be, that is what you are submitting.
My lords,
It is submitted that if it is published in the vernacular language, a show cause notice by an authority who has no authority as per the master circular, as such, that is the prejudice. The constitution of the committee is as per the master circular, and the committee has directed the bank manager to issue the show cause notice. Here, there is no other discretion to the chief manager or no other he is only discharging the duties as recommended by the committee. Whether the show cause, as per the recommendations of the committee, whether the show cause notice is issued by the committee or by the chief general manager, it would not have any kind of impact, prejudice to the petitioner, as it is in furtherance of the recommendation made by the committee. He has simply conveyed it to the petitioner. Petitioner after that, then the remaining procedure as contemplated under the circular paragraph number 3. What is it called? Clauses, or what is it? What are they called? Clause 3.
Yes.
Clause 3 of the circular will have to be followed. Petitioner has not raised any other grounds, as that stage has not come. Petitioner has come to this court and it is submission that no, this show cause notice shall be set aside. Again, the committee shall issue a show cause notice. This court do not find any logic or reasoning in the submission of the learned counsel for the petitioner. When a circular is issued, the whole purpose to be achieved by the said circular is to see that the party will get a reasonable opportunity and consideration by a reasonable committee. Because if that is not followed, the rights of the parties would be affected. In this case, the court do not find not even one reason why the petitioner is aggrieved by this show cause notice, because whatever is contained in the show cause notice, that is issued by that is as per the recommendation of the committee, and the chief general manager has no discretion in this. In that view of the matter, this court do not find any reasons to interfere. Accordingly, the writ petition is dismissed, and the judgments that are cited by the petitioner do not come to the rescue of the petitioner in view of the above discussion made. And this aspect was not considered either by the learned single judge, by the coordinate bench of this court.
Cell number 37, Mohammed Tahir.
30?
37.
Yes. Ask it.
Cell number 37.
Tomorrow. Yes, next.
Cell number.
Look at it if there is any. I think it was argued.
Mohammed Tahir, he has not understood what he has done. Some other advocate. The card is passed in some other part. And no order is passed.
Tomorrow, if look at it, if interim order is there extra.
Cell number 41. Bhushan C.
First matter.
That's the first matter, my lord. I need some time, my lord.
Lordship, he had mentioned in the morning that the borrower is, the person who died has the property can't be given an auction because the person is dead. But he's not the owner, nor is he is a partner of the firm, your lordship. That is clearly mentioned by me in my objection statement.
My lords, can I submit? My lords, can I submit, my lords?
Yes.
It is number 15, my lords. 5/12/2016. There is a demand notice given by
Page number
15. That's 5/12/2016. There is a demand notice given by the respondent bank. One five minutes. Lords, in this serial number 9, Lakshmikant Shetty, my lords, guarantor. Lords, the first property, they themselves in the demand notice state that the property is owned by Mahalakshmi Agro Foods firm at page number 20.
So he's a
My lords,
guarantor.
page number 22.
Guarantor, your lord,
My
just a
lords, like-
guarantor.
One
He's
minute.
not the owner of any properties, your lordship, mortgage.
Which are what,
Yes.
which are now.
And yes, your lordship,
scheduled
and
to
the
be
property
auctioned.
is mortgaged by the firm which he is not even a partner.
Yes.
My lords, page number 22.
Yes.
Lakshmikant Shetty, one of the guarantor of this loan, subject loan, died on 15/1/2017.
What is the property mortgaged by him?
My lords, the property is not mortgaged by him,
Then how
but
is
he
the
is one of the
guarantor?
guarantor. My lords, in SARFAESI rules, all the SARFAESI notices have to be issued by respondent bank in favor of borrowers, co-borrowers, and all the guarantors. In this case, there is a guarantor which he was not at all alive on 18/9/2017. My lords, that is not that is one of the illegality.
Answer to my query. I said, what is the property mortgage and how he is stood as a guarantor?
My lords, the property is not mortgaged by him, my lords.
And then how
He
is
is one of the
guarantor or what?
guarantor.
Huh?
He is one of the guarantor, my lords.
How? Otherwise, what is the guarantor means there should be some property, something. What is guarantee?
Yes, my lords, that's why, my lords, I have filed NOC. I need some time. Next week, I'll convince this court on the.
What is, how he is a guarantor?
The lordship, he's a father. I mean, he's just because the loan amount is huge, extra guarantor they would have taken.
So, like, is it a procedure like that without anything, somebody will be a guarantor?
I don't know,
No,
your
no,
lordship,
he
the
is-
sanction letter, they have not mentioned the ownership. I've given to produce the sanction letter. He's just an individual. He stood as a guarantor.
I'm just asking you about your bank activities. How one will be a guarantor and what is the mode of, how it will be?
Guarantor is only when the borrowers do not repay, then they come into the shoes of the guarantor. Then his
no.
property will be considered. Till then, we are not touching on anything at
So
all about
unless
him.
and until some property is mortgaged by him, we call him a guarantor of the, and what is the other modes of guaranteeing the?
Lordship,
debt?
sometimes the financial background is good of the third
Oh,
person.
that's his word? That is his word.
Doesn't say anything that way, but then they have made him a guarantor, but then he's not in the as per the
To
surface.
appear for the bank, court is not able to understand. You have to enlighten the court on that. What is this guarantee?
There are about 9 parties. Guarantee is for in case the loan does not, in case there is excess,
Where is
in
the-
case the
where is the
lordship, in
loan
case the
agreement?
property mortgage does
Where
not
is-
suffice
This is
the
a loan agreement.
the loan agreement mortgage. Here the question of loan agreement does not arise, your lordship.
Whatever
because
it is, how he has become a guarantor, some document will be there.
sanction letter is there, your lordship. I produced the sanction letter.
I mean, what does it say?
It doesn't say much about it. All it says is he's guarantor number 9, your lordship. I produced the sanction letter, wherein in page number 5,
My lords, can I submit this? My lords, admittedly, he is a guarantor. My lords, page number.
No admission, let us
My lords,
understand the facts. We will not admit like that.
My lords, that's why, my
First of
lords,
all, who is the respondent?
Union Bank of India.
Union Bank of India, your lordship.
Union Bank of India, my lords.
It was a corporation bank before. Corporation bank before, now it's Union Bank of India.
Yes. You have to, I want that clarity on that, how he is a guarantor.
Much obliged, your lordship.
The correspondent bank by the next date of hearing should clarify what is the nature, when they say the petitioner, the respondent is a guarantor, what is, how and what is the nature of the transaction?
My lords, interim order has to.
Is this matter?
There is no interim order in this matter.
There is
So
an interim order.
sale is over, your lordship. In this
My lords,
particular
there is an
matter-
interim order.
there is
Status
no-
quo is there, my lords.
Not in this matter, your lordship, not in this matter, because sale is
Sorry,
over,
let
third
me
person
look
has
at
already
it.
purchased the property,
If it is there, it
2017.
will be
Yes, my
extended.
lords, there is an interim order. There is a status quo ordered by coordinate bench, my lords. There is an interim order. It has been extended from the instance of the writ petition.
No, this WP 25562. There is only one docket or two. There are two writ petitions.
One writ petition, Your Lordship.
Huh?
One writ petition.
Huh? No, this is 25562.
Yes, Your
Where
Lordship.
is the order in 25562? That I want to see.
Yes. My lords, 12/3/2024.
That is not pertaining to this.
Yes, my lords, but this
That is the
status.
common order passed on.
The order is very clear that wherever there are interim orders in these writ petitions, there are. Whether it is in this writ petition or not, I want to see. WP number 25562, not the common order. 25562. This order.
My lords, can I,
Tag this petition along with WP number 58.
my lords, 3833 of 24 and 5144 of 24. And the last line, therefore, status quo with regard to subject property, all these petitions
What
maintained.
is this under section 17 of the Surface Act?
My lords, this is on the ground of delay. All these matters
Only
are
because
clubbed
of delay.
together and there is a status quo order in all the petitions.
No, not in all, Your
The
Lordship.
difficulty is without dealing with that issue, you say that you have come to the other one. No, that is not the issue now to be decided.
Yes, my lords, but there is a status quo order, my lords.
Lordship, sale is over in this property.
Let's
Situation
sale is
entirely
over,
different
but
from
there
the
is a
other
status
properties,
quo
Your
order.
Lordship.
Then we'll have it day after tomorrow.
My lords, not day after tomorrow, next week, my lords.
You can't have.
My lords, next
adjourn-
week, any date after 16.
You
my
want, you want the interim order to be extended and you don't want to
Your
argue
Lordship,
that.
there's no
16,
interim order
my
in this matter, Your Lordship. There is
lords. Status quo in all the petitions.
sale is over and long back in 2017, Your Lordship, and 295 days delay, Your Lordship.
Whatever it is, whatever the status quo
Status
is,
quo is
everything.
Status quo.
And counsel appearing for the respondent submits that. By the time the interim order is granted, the sale is confirmed.
Sold, Your Lordship. Third person is holding the property.
Sale is concluded in the year 2017. After that, what happened?
The buyer is sold. He's the respondent number 2 in this matter, Your Lordship.
The property is delivered to the,
Yes, Your Lordship. He's
Auction
in possession.
purchaser.
but to the auction purchaser. So the status quo order as ordered by this court would be to the, in that case, would dilute to the benefit of the respondent. How it will,
My lords, status quo on the property, my lords.
Huh?
The status quo, there is a status quo on the property with
By the
regard to
time
subject
By the
property.
time the property is delivered to him, what is the meaning of status quo?
Yes, my lords, the property is
Let me
delivered.
clarify, and the status quo order is granted.
What if he
in the
alienates,
end,
my lord?
The petition seeks time. List this matter on, on
After 16th, any date, my lords.
16th.
My lords, after 16th, my lords. My lords, I'll be out of station, my lords. After 16th, any date. My lords.
On 21st, no
Great.
further time will be granted. Yes, next.
42.
Interim order of status quo is extended till then.
My lords, in 25562, my lords, interim order has to be extended.
No, next matter, 22951.
Interim order is status quo.
Status quo.
Status quo has to be extended. Yes,
Extended.
yes.
Status quo, if any. Your Lordship may
2295.
mindfully mention status quo if any, Your Lordship, because in case it's not there, it will become a.
It is there, I have seen it. I've seen
Much
the order.
obliged, Your Lordship.
Yes, 22951.
42.
These are matters with regard to limitation grant. Your lordship is already held that,
So you're saying division by the Supreme Court
then
order.
there are 2 division bench judgments.
Supreme Court order.
I have got the Supreme Court judgment also. I'm just trying to assist the court with regard to the.
Huh?
They have not been served copies.
No, I am appear for the respondent, petitioner, I can serve a copy. If you want, I can serve a copy to everybody.
I need a copy to see what.
I can only serve
what
a
is being
copy to the
submitted
petitioner in
court.
this petition.
Look at this judgment, what is this?
For the first month, property company.
The
private
property company private limited versus
Rohington Daddy Mazda.
Rohington Daddy Mazda.
Yes, ma'am.
Arising out of civil appeal number 92 of 2026.
The
It is
lordship-
submitted by the learned counsel appearing for the bank that the issue with regard to the limitation is decided by the Honorable Apex Court in the judgment. No, as you have taken on that the property company private limited versus so and so. Land counsel appearing for the petitioner seeks time, list this matter tomorrow.
On 20.
41.5. If you want, Lordship want me to highlight the paragraphs, I can do it.
Please give him, he'll highlight the paragraphs and. Yes, 41 point, interim order, look at it, if it is there, extend it till tomorrow.
My Lords, appear for the petitioner in 41.2. Lords, I request a week's time, anytime, any day next week. Any date next week, my Lords, appear for the petitioner in 41.2. Can the matter please be listed next week, my Lords?
No. Ours is 41.5.
41.2, who appears? Vaishya Bank.
41.2.
Vaishya Bank, who appears? You appear?
I'm not a panel.
Who are the panel counsels?
Panel Vaishya Bank, nobody is given the name.
Vaishya Bank has been merged to.
With
Vaishya Bank has been merged to Kotak Mahindra Bank.
Kotak Mahindra. Kotak Mahindra, who appears?
Kotak Mahindra, I appear. But I have to say, I
You appear?
appear for Kotak Mahindra. I appear for Kotak
Yes,
Mahindra.
so and so, Mr. Xavier is directed to take notice on behalf of the respondent bank. Land counsel the petition shall serve the copy without even notice to the respondents from 2024 interim order.
As notice was issued, my Lords.
The shall serve the copy of the writ petition on the counsel for the respondent. Interim order earlier granted is extended till the next date of hearing. List this matter on 21st of April, no further time. Serve on him the papers. Yes, next.
In 41.5.
Huh?
In 41.5, my lords, I have been instructed by my client that there is a notice offer which is given, which is considered, it's pending consideration. And I have-
My lord, in this matter, my lord, the first he has given the offer that has been rejected. We requested him to enhance the offer, but he has enhanced the offer that is also going to be rejected, my lord. We have already told him.
Lords,
this
I have
offer- Well, one
prevailed
second.
upon my client.
What-
If there is something which he can sit and negotiate with the bank and do it, we will do that, my lords. We will improvise and give it, my lords.
Same in the, like the earlier, 1 minute, like the earlier one, same date, at the request of land counsel, the petitioner. As far as this aspect is concerned, you can always negotiate with.
Yes, ma'am.
List this matter on the same day, look at it, interim order is there, extended.
Much obliged.
No, whatever dates they are given. 41.4 is already heard and date is given.
My lord, the tag with the. this matter,
41.5 on the same day. Let it come independently, not necessary.
No,
Let
this
it
is
come
all-
independently, we'll decide. If we decide it tomorrow, it will follow in the other cases also.
Yes, my lord.
Yes.
My lord, in this case, my case is, my lord, my submission is that 65 crores is the outstanding due. Interim order has been, unconditional interim order has been taken. Thrice we have given the.
Then why did you not reject their case for OTS?
We have already rejected
My
thrice.
lords, my lords,
One-
may I
one-
submit
one-
this,
one
my
sec-
lords?
one second.
We have given an OTS offer for
One sec.
some amount, my lords, and 5 crores is already deposited
My-
in
my-
no-lien account, my lords.
65.
My
is
my
amount,
lord,
five
one
is
sec-
now, my
one
lords,
sec- one
now-
second. I am permitted to submit, madam. One sec. Thrice, my lord, the OTS has been given, that he has not been complied with. My lord, when the matter was listed after lapse of 2 years before the coordinate bench, we have raised these questions. Unconditional interim order has been given. Delay is one of the aspects that does not prevent the other side to pay the balance outstanding due. When the court directed them, you propose how much you are going to give. Immediately, my lord, again, the borrower approached the bank for OTS.
Next date of hearing, whenever it is coming up that matter, I'll not adjourn it, I'll hear it. Irrespective of whether you have done the OTS or not, I'll pass orders on the merits of the matter.
Much.
Yes. Yes, next. Dealing to all, whatever is independent order, let it be. No, yes.
Short date may be given this matter.
When is it given?
21.
There are so many matters, I can't take it up. Yes, next. Yes, next.
Serial number 48,
42, madam.
That's 42.
42.
serial number 42 1.
Yes.
Lords, the copy of the petition has been served to the bank, Milaj, and the bank has assigned some other counsel, Milaj. The, Milaj, already this case has been handled by another counsel in DRT. The name is Ramanand Achar, Milaj. His name to be added.
Write on a paper, print the name of so and so. List this matter next week.
Lords, the Divya Purandar name to be
Take the
taken out.
name of Divya Purandar. List this matter on 21st of April.
21st, 24th, your lordship. 24th. 24th. 24th, your lordship.
24.
Please.
Yes, next.
Cell number 48. TP Muttanna.
Lord, your lordship may kindly see my writ petition annexure C. Registration of security interest acknowledgement report. Sarsai,
Page number?
page number 21.
20?
21, my lord.
Yes.
Sarsai report, registration of security interest.
Hmm.
So this is what that is 26C refers, my lord. Wherever registered here.
No, I'm not able to understand. What is that?
26C.
20?
21, page number 21.
Huh.
Sarsai, that is a registration, security interest registration.
Hmm.
That has been done. That EMT by way of deposit, and this the registration of security interest also has been done. And this is mandatory now.
No, by doing all this, we are giving unnecessary power to the registrar, isn't it? He's going to decide what is, who has the charge over the property. No, encumbrance doesn't reflect. It's a fact. According to you, registration of the mortgage is not compulsory. That's what you are saying.
Yes, that's.
No, the registrar, now he has to, basing on your representation of the bank, he should say that there is a mortgage in favor of the bank, and the bank will have the first charge. Why should he say all that?
Oh my, this is all the 4 judgments says, because in one judgment, Kerala High Court Division Bench says you have to, director, that registrar cannot deny. If it is under Surface Act, one CL certificate is issued, he has to register CL certificate. That is what this is, all this judgment says, my lord. Because otherwise, what will happen?
What you are asking, you are not asking that.
No, I am asking only sub-registrar offices. It has to be registered.
That's what, why should he say all that? We are not in a given case. Generally speaking, now basing, why should, what is the endorsement? Why should he do any endorsement on that? What contemplates? Does the act contemplate that he should do it?
No, my lord, that wherever this is there, they have to represent to that registrar. That as per section 26 and all, it has to be registered, because that bank has got priority over other charges. Now, in this case, particular case, my lord, that without original documents, they have entered into register that.
You should have questioned it. You should have questioned that entry by the registrar.
That is why I have written letter. That is why he has not replied. That is why I have come to the court. I have written letter to the sub-registrar office.
For that, you file a writ petition.
That is why this petition is filed.
Not a DRT writ petition. It is not under the Securitization Act. It is independently or questioning the action of the registrar. It would go before the competent court.
This property has been sold.
Whatever it is, if without the original documents, registrar has done something which he is supposed to verify and he has done, question the action of the registrar, and it would not fall under the DRT matter.
But in all these reported
No,
decisions, pass like this.
We are not.
Because now
31 is clear, madam.
Specifically.
Kindly see the primary, seeking for deletion of encumbrance entry relating to the property, madam. He has to approach the civil court, madam, under section 31 of space.
No, otherwise also, if he feels, let him go before the court,
But my lord, contra entry can be made, my lord. This is the contra entry means that entry will remain. We are not defacing that entry. One more entry, because that is what this court says.
Sure, it is not about the bank.
In this, my lord, in this particular case, what happens? Now the registration deed that it is not registered. If it is registered, means you will become the owner, and this will continue forever, and then the bank cannot be sell this property. Now this 4 judgments, my lord, similar matter now. In this all judgments, similar matter, they have invoked regulation 26 years, that judgment they say, because they have got the priority and they have the right, the sub-registrar cannot deny registration.
Sub-registrar, where did he deny your registration?
No, we have written letter, he is not.
If he's not, for that you will not file a writ petition before this.
But here also you have produced, my lord, that what he has not replied, you have
Let them
mentioned.
entertain. I am not interested to entertain this writ petition. If you want to take a chance, yes, file your objections. The respondent shall file their objections. This next.
Number 2, for order CL number 1.
This is matter after vacation.
De facto complaint, my lord. I would take a fresh steps. In the meantime, there is a civil suit also filed.
First time, 2023 matter, process is not paid even till now.
My lord,
What is the interest the petition is showing?
my
It has
lord, it's
become
a
infructuous.
de facto, my lord,
We have
de
already
facto
issued-
complaint.
Whoever it is, if you have made him a party, you have to serve notice on him
My lord, I
to
would
pay the process. That means you're not
paid the
interested.
first time it is coming up, my lord.
No, it's not about coming. It's your duty to pay the process after the notice is ordered.
My lord, I would also take answers on
What is,
invoice.
what
Has
is it?
become,
My lord,
Give the, what are your instructions?
Lord, they have appeared before the IO and you have given statement, my lord. And there is a suit is also pending between the parties, my lord. Therefore, my lord, the respondent police has given endorsement, but suit is pending before the trial court and it has to be adjudicated by the civil court only, my lord.
civil court, then it can be closed now. I've challenged the police notice.
Sir, Ishwari, set aside the notice.
Yeah, my lord, civil,
Police
on the
notice.
civil side, my lord,
The
there.
writ petition is fine.
They have appeared.
Questioning the, seeking the following relief. When the matter came up, HCGP submits that pursuant to the notice dated 31/12/2022.
Notice was
Petitioner appeared before the respondent number 2 and gave his statement in respect of the, and also stated about the dispute, that is OS number 155/2021, pending before the civil court, Anekal. Full stop. Since the dispute is civil in nature and the suit is also pending, the respondent number 2 has issued an endorsement stating that the said dispute is civil in nature and the dispute has to be resolved in the civil court. In the light of the endorsement dated 5/4/23.
5423, my lord.
5/4/23, nothing survives for consideration in this writ petition. Accordingly, writ petition is dismissed as infructuous.
Number 2. Number 2, Vasudeva.
Can be disposed of, my lord, because it is given after the filing of
Light
the.
of this, so and so the writ petition, no, it is, now at this point of time, it is infructuous.
My lord, that endorsement is
Light of
issued.
the endorsement dated so and so, it is disposed of.
Please, ma'am.
This too.
My lord, in this matter, my lord, page 62, same endorsement has been issued by the respondent police, my lord, that has been
You
questioned.
have the
before
copy
this court. No, my lord, it is produced by the petitioner himself, my lord.
himself.
That
Then why
endorsement
did he
is-
question it?
that
Then
endos-
we'll post it for dismissal. No representation, post 5 o'clock. We'll see tomorrow. It's already 5. How many matters? 2. All these matters repeat tomorrow. If any interim order is there, extend. It's already 5 o'clock. Yes.
My lords, a brief mentioning, please, my lords. List 2, serial number 6, my lords. I kindly request it may be dismissed as withdrawn, my lords. I'm filing my memo.
Serial number?
List 2, serial number 6, please,
Take
my
that.
lords.
On serial number 10, the advocate on record has undergone.
Huh.
It is stated that a memo is filed stating that the petition is not interested to pursue the matter. And the dispute is amicably settled between the petition and the respondent number 2. Accordingly, memo is taken on record and dismissed as withdrawn. Yes.
Grateful, my
To
lords.
serial number 10, Your Honor, the advocate on record has undergone surgery. Could be taken up on the next week. Your
Yes, next week, serial number 10. Yes.
My lord, serial number 4, my lord, PF has been paid, steps has
What
been
is serial
taken.
number 4?
So in this matter, my lord, the complaint was given against the circle police inspector before the commission.
Against the?
Against circle police inspector, my lord, before the commission of police. I have to get instructions, my lord, day after tomorrow or next week. any
Is
day,
this
my lord.
matter next week?
This-
Serial number?
Interim order may extend it.
Serial
my
number
lord.
4,
Serial
bill
number
4.
Causes to
Next week, interim order is extended. Yes.
causes to serial number 3, my lords, against respondents 2, 5, 6, 7, PF has been
We'll
paid.
forget about the PF now. Now it is all old matters. We'll
My
find
lord,
out.
serial number 11, my lord, serial number 11. My lord, the freezing of the account has been called in question, my lord, issued by the bank. My lord, the entire matter is now stayed by the Honorable Supreme Court, my lord, in SLP. And my lord, I'm filing a memo.
Tomorrow. I'll see when the matter comes tomorrow.
Madam, ಯಾವಾಗ withdraw ಮಾಡಿದ್ದು serial number?
ಎಲ್ಲ ಕಳಿಸ್ತೀನಿ. ನಾನು repeat ಕೊಡ್ತೀನಿ. ಅದರಲ್ಲೇ ಬರೀರಿ. ಇಲ್ಲೇ ಬರೀರಿ. ಫೈಲು ಸೈನ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಬೆಳಗ್ಗೆ ಕೋರ್ಟ್ಗೆ ನಾಳೆಗೆ ಯಾವುದೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅನ್ನೋದು ಡೇಟ್ 16 ವೀಕ್ ಅನ್ನೋದು 16 4 ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 4 16 ಸೀರಿಯಲ್ ನಂಬರ್ ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 10 16
ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಏನ್ ಮೇಡಮ್ 16
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಾಳೆಗೆ ಅವ್ರೇನು
ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಮೇಡಮ್
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಾಳೆ ಅಲ್ಲ ಇಲ್ಲ 1 ಡಿಸ್ಕೌಂಟ್ 2 ನಾಳೆ
9
ನಾಳೆ 4 16 ಹಾ 5 4 16 4 ಆಯ್ತು 5 7 4 ನಾಳೆ 6 ಡಿಸ್ಕೌಂಟ್ 7 ನಾಳೆ 7 and 8 7 4 ನಾಳೆ
9 ಮೇಡಮ್
9 ನಾಳೆ ಸರ್
ನಾಳೆನಾ
ನಾಳೆ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
11 and 12 ನಾಳೆ 9 ನಾಳೆ 10
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮೇಡಮ್
12 ನಾಳೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ 16/4 ಡೇಟ್ ನೀನು ಉಳಿದಿದೆಲ್ಲ ನಾಳೆನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಒಂದು ಬೆಳಗ್ಗೆನೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 9
ನಂಬರ್ 9 ನಾಳೆ
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರೋದು ಸೆಕೆಂಡ್
ಸರ್
ಲಿಸ್ಟ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲ ಇದೆಲ್ಲ ಜಿಎಂ ಪೊಲೀಸ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬರೋದು ಅವ್ರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡು ಬೋರ್ಡ್ ಅವ್ರಿಗೆ ಗಂಟಾಗಿ ನಾಳೆ ಇರೋದು ಬರ್ದ್ಬಿಟ್ಟು ಕಳಿಸಿ ನಾನು ರಿಪೀಟ್ ಕೊಡ್ತೀನಿ 47 48 ಇದು ಇದರಲ್ಲಿ ಕೆಪ್ಪಿಲ್ಲ ಎಲ್ಲ ಡೀಲಿಂಗ್ಗೆ ಅದೆಲ್ಲ ಇರುತ್ತೆ ಫೈಲ್ಸ್ ಎಲ್ಲ ನೀವು ಬರೆಯುವಾಗ ಆ ಮೈನ್ ಫೈಲ್ ಒಂದು ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ಫೈಲಲ್ಲೂ
ನಂಬರ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಅದ್ರ ಸಿವಿಲ್ ಅಪೀಲ್ 92 ಅಂತ ಪ್ರಾಪರ್ಟಿ
ಅದೆಲ್ಲ ಫೈಲಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿದ್ರು ಫೈಲಲ್ಲೇ ಇದೆ ಅನ್ಸುತ್ತೆ
ಅದು ಕಾಪಿ ಕೊಟ್ಟರು
ರುದ್ರಭೂಷಣ ಯಾವ್ದು ಕಾಪಿ ಕೊಟ್ಟರು ಒಂದಾ ನೋಡೋಣ ಇದೆ ಕೊಟ್ಟು ಇಲ್ಲೇ ಇರುತ್ತೆ ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು petition ಏನಪ್ಪ ಮೇಡಮ್
ಇಲ್ಲ
ಇದ್ರಲ್ಲಿ ಇರ್ಬೇಕಂತ ಇದ್ರದ್ದು ಇದು ಡಿಸ್ಕೌಂಟ್ ಇದು ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಇದು ಒಂದು ನಿಮಿಷ ತೆಗಿ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ
ಅಲ್ಲ ಇದು
ಅದು ಅದ್ರದ್ದೇ ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2 ದೇ
ಸೀರಿಯಲ್ ನಂಬರ್
1 ಅಲ್ಲಿ ಡಿಸ್ಕೌಂಟ್ ಆಯ್ತಲ್ಲ ಅದು ನಮ್ಮ ಫೈಲ್ ಇಟ್ಕೊಳ್ತಿಲ್ಲ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಾಳೆ 2 ನಾಳೆ ಅವ್ರು ಬಸ್ ಕಳಿಸ್ತಾರೆ ಫೈಲ್ ಒಂದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಒಂದು ತಗೋ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಅಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಇರು ಅವ್ರ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ನಾನು ಇಲ್ಲಿ ರಿಪೀಟ್ ಆಗೋ ಫೈಲ್ಸು ಎಲ್ಲ ಫೈಲು ಕೊಟ್ಬಿಡೋದೇನೆ ಯಾವುದು ಇಟ್ಕೊಳ್ಳೋದಿಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಒಂದು ಡಿಸ್ಕೌಂಟ್ ಆಗಿದೆ ಅದೊಂದು ಒಂದು ನಿಮಿಷ ಸೀರಿಯಲ್ ನಂಬರ್ 274
ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳ್ಬಿಟ್ಟು
ಅದೇ ಅದೊಂದೇ ಹಾಕೋಣಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಒಂದೇ ತಗೋಬೇಕಾಗಿರೋದು ಇಲ್ಲ 6 ಡಿಸ್ಕೌಂಟ್ ಅದು ಫೈಲ್ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡು ನಾಳೆಯಿಂದಲೇ ಅವ್ರು ಮಾಡ್ಕೊತಾರೆ 6 ಒಂದು ತಗೋ ನೀನು 6 13 ಒಂದು ಅದು ಬೆಳಿಗ್ಗೆ ಅರ್ಜೆಂಟ್ ಆಗಿದೆ ಅವ್ರಿಗೆ ನಂಬರ್ 13 ಒಂದು SMC 7 SMC ಲೈತಾ
ಲಲಿತಾ ಮೇಡಮ್ ಕೊಡಿ
ಇದೆಲ್ಲ ಇದೆ ಗೊತ್ತಾಗಿದೆ ಹಲೋ ಒಂಚೂರು ಬರಬೇಕು ಕೋರ್ಟ್ ಆಗಿ ಬೇಗ ಲಿಸ್ಟ್ ಕೊಡಿಲಿ ರೆಡಿ ಮಾಡ್ತೀನಿ ಲಿಸ್ಟ್ ತಗೊಂಬಪ್ಪ ಆಚೆ ಕಡೆ ಇರೋದು ಲಿಸ್ಟ್ ತಗೊಂಬನ್ನಿ ಇಲ್ಲಿ ಇಲ್ವಾ ಒಂದು ಇಲ್ವಾ ಯಾರಿಗೆ ಒಂದ್ ಎಕ್ಸ್ಟ್ರಾ ಕಿತ್ಕೋಬಾರ್ನೆ.
ಇದೆಲ್ಲ ರಿಪೀಟ್. ಎರಡು ಫೈಲ್ಸ್ ಡೇಟ್ ಇದೆ ನೋಡಿ.
ಅದೇ ಇವಾಗ ಸೈನ್ ಮಾಡ್ಸಿರೋದು
37 61 37 60
60 ಬನ್ನಿ.
ಮ್ಯಾಮ್ ಈ 41 ಅಲ್ಲಿ ಮ್ಯಾಮ್ ಒಂದು ಬಿಸ್ನೆಸ್ ಆಗಿದೆಯಲ್ಲ ಆಮೇಲೆ
41 ಅಲ್ಲಿ
41 5 ಪ್ಲಸ್ 5 ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರಲ್ಲ
ಅದರೊಳಗಡೆ ಬೆಳಗ್ಗೆ ಒಂದು ಆರ್ಡರ್ ಹಾಕಿದ್ರೆ ಇನ್ನು ಉಳಿದಿದ್ದೆಲ್ಲ ಈಗ ಡೀಲಿಂಕ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಕ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ. ಇನ್ಯಾವುದು ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ, ಅದು ಯಾವ್ದು ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ.
ಇಲ್ಲ 41.1
ನೋ ಅದೇನೆ ಅವತ್ತೆ 21/4
ಎಲ್ಲ 21
21/4 ಸೆಪರೇಟ್ ಆಗಿ ಬರುತ್ತೆ, ನಾಟ್ ಲಿಂಕ್ಡ್. ಎಲ್ಲ ಸೆಪರೇಟ್ ಆಗಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳೋರು ಮೇಡಮ್.
ಹೌದಾ?